That's great news. And then I just started the recording for the meeting, FYI. We'll be posting this online, everyone. Once we finish the meeting, it'll get posted onto our website in a few days. So it will be publicly available for perpetuity. Let's see, next up, Jordan.
Good morning, Jordan Kilby. I am a private attorney, and I have just been working with Brett, Celine, Aldina, and Hope on getting ready for this presentation.
Thank you. Emily?
Good morning, I'm Emily. I'm a forensic nursing program coordinator at Bozeman Health, and I've just been seeing all the patients.
Which is not just anything. That's a pretty important part of the process. So thank you very much. Detective Guderian.
Good morning. Since last meeting, I took some time off to care for my grandma who had a hip replacement, and then just the usual casework, and also been searching the landfill. So it's been a lot of fun over here.
Yeah, you've had a hard case up there that lots of folks have been assisting with. Thank you for your service on that. Eldina.
Good morning. I was trying to remember when our last meeting was. That's what it feels like right now. I haven't really been doing any traveling other than going to North Carolina to see my daughter and my son-in-law, and we saw Justin Timberlake. Because I'm the concert part of this band, I think. And other than that, just getting ready for the legislature, like I think most state agencies are.
Very good. Justin Timberlake. That sounds like a fun concert.
It was. We had bets on the age ranges, and it really was more like my age than my kids' age. So it was a good time.
All right. Let's see. Up next, Mark.
Hi, Mark Horn from Eastern Montana Telemedicine Network. We have been eagerly awaiting Congress's decision on whether they are going to extend the waivers for virtual healthcare. So nothing yet. I understand that the 20th is the deadline, so we'll see what happens.
Mark, what does the waiver allow?
So the waivers were from COVID, and they allowed direct to patient. Telemed is the main thing, but also waive some of the regulations around where patients can be seen. So it's hard to plan for January 1 when you don't know at this point.
Well, thanks for sharing that. I wasn't aware of that. I had not been tracking. That is an important part of the discussion. Good morning, Jamie.
Good morning. My name's Jamie Bray Tanner. I'm the biology supervisor here at the Montana State Crime Lab. We are currently bringing on 3 new DNA analysts, which should help address some of the backlog needs. The new gal is going to be completing her training tomorrow. So we're very, very excited, with 2 others completing part of their training and being able to assist in report writing and interpretation in February and March of next year. Personally, I have a 5-year-old right now who is all about Christmas. We did the Elf on the Shelf, which is fun and maybe the death of me. So I don't know. It should be fun. It's been busy. So
Well, that sounds like fun stuff all the way around, especially with the new analysts. And I resisted the Elf on the Shelf this year with my 5-year-old. I didn't pull it out and she hasn't asked, so I'm just letting it go.
That's really smart.
Let's see. And then Brenda. Oh, no, Brenda, you spoke. Sorry. End of year, your training work and assessment work. Celine and Whitney are here in the room with us. So Celine, I'll turn it over to you first.
Hi, everybody. Since the last settling into the new role and getting used to not being on the road, which is a real adjustment. Also working on 1 case and only 1 case for the last month has been a total, it's just messed with me a little bit. I have a 4.5-year-old, and so we too are really getting ready for Christmas. Friday, we went to Lewistown for the North Pole Adventure on the Charlie Russell Choo Choo, and it was Kale's 3rd time on there, and he just loved it. He knew everything that was going to happen. He was telling all the other kids, and it was just really, really special. So
Sounds really fun.
yeah, I don't do Up on the Shelf. I won't do Up on the Shelf. So yeah, Jamie, all the props to you for doing those because it's a lot of work.
Whitney?
My name's Whitney. I'm the forensic nurse coordinator at St. Peter's here in Helena. Since our last meeting, hasn't been a ton of new and exciting things going on, just trying to wrap up some projects that I had going through 2024, and I'm all about end of year reflections and goals for 2025 and things like that. So just working on that, and yeah, nothing too exciting.
All right, let's see. I see, just make sure we've got everybody, all the committee members who are here in the room. We are missing a couple of folks this morning, so I'll add them into the Zoom as we come on. For the record, I'm Hope Stockwell. I'm the Sexual Assault Response Network Coordinator at the Montana Department of Justice. And this morning, we're not in the Capitol running the meeting with the graces of the legislative Zoom services and MPAN. So we're operating out of the Missouri building here at the Department of Justice. And I'll just ask for a little bit of grace because I'll be managing the Zoom along with other things. And so I will do my best to keep on top of everything. We've got Kayla Bragg here in the room with us, our Director of Office of Victim Services. She's taking our minutes log during the meeting. Kayla, anything you'd like to add this morning before we get started?
I don't think so. Thanks for setting this up. We're enjoying our new building where OBS moved to the, I'll say it probably with the country slang, the Meserac building. But we're here, and I guess I can share a few updates about OBS.
Sure.
So with our crime victim compensation program, the Holly Johnson, our program manager, is working on updates to the victim compensation claim form and instructions. So we hope to get those out in the new year. So if you're helping victims fill out the claim form, you'll have instructions on how to do it. And then also we're just updating the form in general. The address confidentiality program and the Hope Card program, we are developing, IT is developing a victim services online portal. And so those will be electronic, the opportunity for folks to do an electronic application. So we're really excited about that. And I can't think of anything else, no other immediate notable updates, but yeah, if you need anything, just reach out anytime.
The hiring of our cold case investigator.
Oh yeah. Yeah, SACI, the Sexual Assault Kit Initiative. We hired Michelle Morgan Roth, the SACI Sec coordinator. She just hired a cold case investigator. And so what this means is that on the 2023 SACI grant, we will have a DCI agent to investigate these cold cases. So when we receive CODIS hits from these SACI cases that are collected and tested, we will review that case with the local community, with the multidisciplinary team, and then we'll have a cold case investigator in the event they want to do a DCI request for that case. So we have resources there for the SACI cases because we know that it's work on top of the work that you are already doing. So.
And then I think what I'd add for the Sexual Assault Response Network program, we've been working, as you've heard at other meetings, about getting the updates to the sexual assault kit implemented. So the changes were settled on this past fall, and submitted to the manufacturer. We are awaiting the arrival of those new updated kits at the end of January, and we'll get them distributed as soon as they arrive. In the meantime, Kayla and I have been working with the nurses and the crime lab on just making sure that we have a good detailed list of all the changes ready to go out. And that memo is expected to go out to everyone affiliated with the KID track system. So medical facilities, law enforcement, we'll get it out to the prosecutors as well, and victim advocates. We'll be doing office hour trainings in January on Zoom, 2 of those. One is Friday, January 7. Well, I better double check myself. I will have to pull it up and report back on that. But we have 2 office hours established in January that we'll be sending out to the public, the medical facilities, law enforcement, et cetera, so they can be up to date on the latest changes in the kit. Share the word on that. Very excited about getting that going. And then we're also in development of a prosecution training for prosecuting sexual assault, using a combination of Montana and national speakers, April 23rd through 25th in Helena, and we'll be sending out the save the date to county attorneys and city attorneys in the next couple of weeks, most likely, and then hammering out that agenda as we get a little closer. So lots of things going on at the Office of Victim Services. It's been a pretty exciting fall, I'd say, overall. Yeah,
And your dates are the 17th, which is a Friday.
thank you.
And the 29th, which is a Wednesday for office hours.
Those hours are, so January 17th and January 29th, and they're both from noon to 1 p.m. And anybody who might be listening and is interested, should you not receive the invite for some reason, please email dojsarn@mt.gov to get that information. We'll make sure the committee members also have the information and the memo detailing all the changes in the kit, should you receive questions or just be interested in attending yourselves. All right, well, with that, we will begin the December 16th presentation of the Sexual Assault Response Network Committee. We have 4 presenters this morning, Brett Irigoyen, Celine Kepke, Jordan Kilby, and Aldina Bear-Don't-Block. And I will get the screen share going here with our PowerPoint that they developed, which is interesting that it is not. Sorry, this is where y'all are gonna have to give me a little bit of grace. I have so many windows going that Sorry, y'all, I'm running 2 apps at the same time, and it seems to not like having that going between the room feed and the Zoom feed. Kayla, I might need you to go into the OBS share drive. It was working earlier, but I'm not seeing it now.
And what do you?
In the SARN committee folder. Oh, here it is. All right, we got it.
Okay.
All right. Can everybody see that come up? Out in Zoom land? I'll work to get it going. In person attendance. Can somebody give me a verbal thumbs up? Or that you're seeing the screen show right now?
Yeah, I can see it.
Okay, that's great. Thank you. All right. So I will ask our presenters to take it away. Catch us up. And just a content warning for the day. For anyone listening, we will be talking in depth about sexual violence and its impacts. We're focused today on the criminal justice system and both prosecution and criminal defense in these cases, but want to acknowledge that this discussion might trigger personal feelings based on your own experience or someone you know. And so please do take care of yourself if you need to step away for a time, whatever it is that will help you as we work through these hard conversations. But just a reminder, there's always 24/7 support available by calling or texting 988, which is a mental health resource for crisis support if you need to talk to a counselor. And then also you can call 211 to be connected with support resources in your community, such as victim advocates and legal services. So wanting to be sure that we share those this morning before we begin. All right, and with that, let's see, I forget, Jordan, you are up first talking about the foundations of the criminal justice system.
All right, good morning. So the foundation of the American criminal justice system, so essentially why we do what we do and how it works, is found in our Bill of Rights, which, as everyone knows, is the first 10 amendments to our federal constitution. I want to talk a little bit about the history because I think we get kind of bogged down. Certainly, attorneys do in our day-to-day work, and we don't every day think about why we're here and the reasons that we follow these rules. So, back in the mid to late 1700s, the colonists were being ruled here by Great Britain without representation or control, essentially, over their privacy and finances and their freedoms. After the Revolutionary War, which occurred because of that fact, in establishing the federal constitution and the federal government, which united the colonists into our country. But back then, having just come from a situation where an authority far from home had so much control, many people at that time were extremely skeptical of a central federal government having so much power. So and that's essentially what our Constitution did. But in establishing the Constitution, James Madison, working with George Mason and others, formed the Bill of Rights as a compromise to that central government. So in the end, we ended up with a central federal government, but through the Bill of Rights, we were able to maintain our freedoms and individual liberties. Specifically, one of the problems prior to the resolutions for the colonists, and a large part in inciting the rebellion, was what were called writs of assistance. And these writs allowed British soldiers to enter anyone's home and essentially ransack them without good cause or reason. It was a manner in which the British controlled the colonists, and as a result, and to avoid that type of governmental exploitation going forward, the Fourth Amendment was born. And we've all heard of the Fourth Amendment. It's the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. That was part of the Bill of Rights, and all of the rights in the Bill of Rights are deemed fundamental, which means that they're of such import that the government cannot infringe upon them, but for only a few circumstances. Those get litigated a lot, and it's essentially, as criminal attorneys, prosecution and defense, it's the meat of what we do. Likewise, the Bill of Rights bestowed upon us as individuals that the right to due process. That is essentially that the government must follow established legal principles when depriving someone of life, liberty, and property. And that just means that we follow rules. While the rules may seem arbitrary or silly as applied in certain cases, they are in fact, and my whole point in explaining this, I think, is that they are fundamental to our government, to the way our government is structured and how it began. So before we can take away anyone's liberty, we must give that person due process. Here we have the presumption of innocence. The confrontation clauses are all part of our Bill of Rights. We also have the Sixth Amendment, right to counsel and speedy trial. The Fifth Amendment, right against self-incrimination, that's on there. And the Eighth Amendment against cruel and unusual punishment, those are applicable to our criminal justice system. So the reason I talk about this, and the reason we start with this, I think, is in the work that we do, and I remember when I was a prosecutor, I would often get frustrated with defense attorneys, and I'd have and things that they were doing, and I'd have to stop and ask myself whether what they were doing is just an obstruction or it was an extension of the protection of these rights that are so fundamental to our country. You've probably heard that the Constitution is the supreme law of our land, and that is true. And what defense attorneys do, and how most of us see our jobs, is it's not that we love to help people who break the law, or that we, just want people who commit crimes to go free. I mean, that's obviously an oversimplification, but it's actually just the opposite. For most of us, we love the Constitution and the Bill of Rights, and think what our country is founded on, and the reason that folks fought the revolution is so important. So while in especially these types of cases, a lot of defense work feels obstructive, but it's a lot of what we do is really found in the Bill of Rights and the reasons that date back to why the colonists fought the Revolutionary War. So I think that's something that is important for us to recognize, you probably all recognize it, and I just remember prosecuting and getting frustrated with it, but it's an important foundation of our system. And then the Montana Constitution has its own explicit right to privacy in it. And that actually for victims, it is often used as a sword, or sorry, a shield rather. And it's a good thing for victims because it allows for us as prosecutors to make arguments that victim information is not just available to everyone where it may be in the federal system. So Montana has a heightened right to privacy. It's based in from our Constitution that came from, I think, 78. You guys correct me if I'm wrong. And just our kind of culture as Montanans and our individual our philosophies around individualism and privacy. So that's that.
So what we're gonna do today is take you through a really high level discussion of what we as prosecutors and defense attorneys do and kind of what that process looks like over the course. So we'll talk about how the case is referred to the prosecution, what that looks like when we are deciding whether or not charges should be brought, what proceedings look like. We'll talk about then when defense gets involved. And then as we go through all the proceedings, sometimes that culminates in a trial or a guilty plea. If we get to that point in the process, then we'll tell you a little bit about what sentencing and post-conviction looks like. Because contrary to what a lot of people think, once a trial or guilty plea is entered, that doesn't necessarily mean the case is over. And that's something that we really like to stress, especially in terms of our victims' knowledge, because this can be a really, really lengthy process.
All right. So I'll talk to you a little bit about how the case actually gets started here. Essentially, there's typically a disclosure made, and that information is then given to law enforcement, and they'll begin their investigation at that time. In my jurisdiction, and it's different in every jurisdiction, but in my jurisdiction, law enforcement knows that once a sexual assault or sex crime case is referred to them, when the investigation begins, they contact me immediately so that we can start working together on how to best proceed, how the investigation should go, in order essentially to make sure that not only do we get all the evidence, but that we do it in a way that the defendant's constitutional rights are not violated. And so obviously that's very important for the defense, but I would say it's as important or more important for the prosecutor to make sure that the evidence that we do ultimately get and use at trial was done so within the bounds of the Constitution, so that defendant's rights are not violated in any way, so that we can actually use that evidence at trial. We'll talk about that a little bit more as we go. Depending on the age of the victim, and for those of you that use the term survivor, I'm not using the term victim because I am not cognizant of the reasons for using survivor, but in the code that we have to work with, victim is the term that is used throughout the code, and so that's typically the term that prosecutors use because that's the word we have to reference if we're referencing the code when it comes to sentencing under these various sex crimes. But if the victim is a child, then we'll typically try to work on setting up a forensic interview, and Celine will talk about those a little bit more detail in a bit, but essentially an interview that doesn't put anything into the mind of that child, essentially just lets them say their story, say what happened, without putting anything into their own mind, so that we get the most accurate information as possible. We will also work on getting interviews with other witnesses, whether that's the person that the information was initially disclosed to, possibly somebody that witnessed part of the crime, or saw the individuals together. Law enforcement will oftentimes at least attempt to conduct an interview with the suspect, Obviously, they have rights to not self-incriminate. And so those don't always occur in these sorts of cases, but certainly are interviews that are important if we can manage to get them. In these sorts of cases, if a SARN exam is conducted, those medical records will be very important for the potential prosecution of the case. And so we'll either ask the victim survivor to sign a waiver that would allow us to get copies of those medical reports and any other sort of medical information that we may need. If we're not able to obtain that, then we can file for investigative subpoenas to the various medical facilities to get copies of those records so that we can hopefully successfully prosecute the crime if we ultimately determine one was committed. As far as physical evidence goes, we'll work on search warrants if necessary for those, and we'll talk more about that in a bit to make sure that evidence is collected successfully and within the bounds of the law, so that we can use that at prosecution. And then any sort of evidence that involves DNA, we'll work on collecting that and getting that to the proper entities for testing. Historically, we've had to send a lot of that sort of DNA outside of the state of Montana for YSRT. I always say that wrong. So those of you that do it, Jamie, if you want to correct me, YSRT, I believe, testing. But more recently, the crime lab is now able to test that sort of DNA information, which is so helpful for us, so that we can have that all within one location. That cuts down a lot on chain of custody type issues that we may have had in the past, when we can keep that all within the same testing facility. If you want to go forward, Hope. Oh, you were already forward. I'm sorry. There we go. So yeah, with that physical evidence collection, like I said, we may need some extra follow-up, depending on when the disclosure is made. In these sorts of cases, the timing of collection is of paramount importance. The sooner, the better. Any sort of DNA can have the ability to lose its effectiveness over time if it's touched by more than one person. Various different things can happen, and so we try to get that collected as soon as possible. Sometimes that's not possible if disclosure is significantly delayed. That evidence just may not have evidentiary value anymore, and so we try to get that as soon as possible. Now, communications with the victim early on are really limited in scope. We essentially make contact with them through a victim witness assistant or victim witness advocate if the jurisdiction has one. And we really limit that contact at the initial investigation phase just to letting them know that an investigation is underway. The steps are being taken, that we'll contact them if we need anything from them. And obviously let them know that they can contact us if they have any questions, concerns, or anything comes up. And then that we'll get back in touch with them when we get to the charging phase of the case to discuss any possible charges with them. And we give them a lot of deference as to how often and when they would like to be contacted. Some victims want to be contacted once a week, once a month, every time anything at all happens in the case. Others don't want to be contacted at all unless it's absolutely necessary. And so we give a lot of deference to their wishes when it comes to contact, to try to keep them as comfortable as possible, and not have to re-victimize them by having to bring it up over and over with them. And so we just give them a lot of deference in that realm when it comes to contact. Anything else you have on that, Celine?
No, we just, best practice as a prosecutor is try to give the victim as much autonomy as possible, given that they've had so much control taken away from them once they get to this point, typically in a sex case. So we do our best to balance our obligations as a prosecutor with also giving that victim some autonomy. Moving on, so now that the prosecutor's office has all of this information to start to review and go over, one of the first things, at least I always look at, is whether or not we can bring this case under statute of limitations considerations. So statute of limitations is essentially a time limit on certain charges. Generally for a misdemeanor, and a misdemeanor charge is a crime that has less than 1 year of jail time as a penalty. You can bring a misdemeanor charge within 1 year of that incident occurring. And there's a lot of caveats to all of this time counting and that sort of thing, but the goal is to just give a really high level, especially dealing, and we'll get more nuance when it talks to the sexual assault type charges. A felony charge is a crime where there's over 1 year of prison time available as a punishment. Generally, felony offenses have a 5-year statute of limitation. When you move into sex cases, that changes a little bit. For felony offenses under the main sexual assault, sexual intercourse without consent, those types of statutes, statute of limitations is commenced within 10 years of the offense. If you are an adult at the time the offense was committed against you, and if you are a minor or under the age of 18, one of the big changes we've had in the last couple years is if you are a minor at the time the offense is committed against you, that charge may be commenced at any time. We've had a lot of changes in statute of limitation calculation, especially for minor victims. And so it's a real process to go back and look at when the offense actually was occurring. You have to go back and see which statute of limitations applied at the time. And you have to make sure there's a constant carryover. So if you're a minor victim and statute of limitations lapsed at some point, it ran, we can't then reapply this new lifetime look back period. So it just gets really complicated when we're dealing with delayed reports, which a lot of our cases are, especially if they are significantly delayed, like maybe, you know, an older person, 40s, 50s disclosed when something happened when they were 12. It makes it difficult. And I will just say, just because a prosecutor can bring a case within statute of limitations doesn't mean we always will. And that's where the rest of the consideration goes into effect. Moving on, one of the big things we look at is whether this offense had an element of consent. Consent is codified, and I think it was changed in 2017. Prior to that, we did not have a definition of consent. In order to prove that there wasn't consent, you had to look to whether there was force or coercion or something else used to prove a lack of consent. It was really kind of turned on its head for a very, very long time. And so finally in 2017, the legislature changed it. We have an actual definition of consent, which is an expression of lack of consent through words or conduct means there's no consent or that consent has been withdrawn. And it's important to note that consent can be withdrawn at any time. A current or previous dating or social or sexual relationship by itself, the manner of dress of the person involved with the accused in the conduct at issue does not constitute consent. We're really trying to address a lot of those myths that a lot of people who haven't been involved in this kind of work seem to believe, that because someone was wearing a short skirt or was scantily clad some way, that they were asking for it. And it's a totality of the circumstances analysis for the jury. You have to, lack of consent is inferred based on all of the surrounding circumstances and must be considered in determining whether a person gave consent. One of the other things though, when you're looking at consent, at least in the eyes of a prosecutor, is we have to prove in every criminal offense that the defendant, the offender, knew what was happening. There has to be a mental state element to each element of the offense. And so one of the things that best practice as a prosecutor, every prosecutor should be considering, is whether or not, given what was disclosed in terms of the lack of consent, that offender would actually have known that that lack of consent was being communicated to them, either through, you know, a frozen victim who's not engaging in any way, whether that's no, whether that's pushing off. I mean, there's all sorts of different things. But we have to prove as prosecutors that the offender knew that there was no consent. And so again, kind of gets flipped on its head. We're trying to make sure that when we bring a charge, we can prove each of the elements. A lot of times in these cases, we have multiple either interviews or statements that are given by our victim. And I will say this is one of the most frustrating parts for me. Even having the understanding that I do, that each element of the investigation, whether it's forensic nursing, whether it's CPS, whether it's law enforcement, all depending on the type of case, everybody needs to have that basic understanding of what happened in order to do their jobs. But every time someone tells any story, right, not counting, just discounting that it was a traumatic event, no storytelling is the same every time. And when we're looking at whether a jury is going to believe a victim on the stand, we look at these inconsistencies. And so this is one of the times when we're looking at charging where everything that happened prior to the case being brought to the prosecutor's office really starts to matter. If there are multiple super detailed statements with these changing facts or order changing or something like that, it's a consideration we look at. And we do our best to educate our juries as to memory, as to trauma, as to, you know, how memory formation occurs in the brain, especially given a traumatic situation. But it's just one of those things where if we have multiple different statements with really changed events or changed narratives, it's something we're going to have to look at in terms of whether or not we can prove this case. Specifically with children, we in Montana try to do forensic interviews. A forensic interview is a really formal interview, and there are very specific rules that need to be followed in that interview to have a good forensic interview. And the purpose is to allow a child to disclose events if they occurred in a neutral environment. The questions are open-ended, they're non-leading. And it really just allows the child to disclose if something happened to them in a way that isn't suggested or coached in any way. So a lot of the questions are like, I heard something happened to you. Tell me about that. And then there might be a part of a disclosure and it'll be, okay, oh, tell me more about X detail that you just gave. We again use experts. We use our local forensic interviewers to explain this process. And it's another thing that we look at if there's a lot of suggestion in an interview, if the interview just really isn't done well, especially with a very young child, it's a consideration we look at in terms of bringing the offense. Brett, anything else?
No, I think that's good, Celine.
When we look at an offense, most of these sexual assault type offenses are often just with the offender and the victim present, right? We don't have, most sexual offenses don't occur in a crowded mall or something where we've got cameras or something like that. So even though I really hate the term he said, she said, that's in plain terms, understanding that's typically what we have to go off of is the victim's account of what happened and the offender's account of what happened. And so some of the things that we might do is try to find someone or something that might substantiate a really innocent detail that maybe these two people were together at the time that this was alleged to occur, or that you know, I remember one case I had when I was a prosecutor in Missoula, a minor victim had alleged that she was assaulted, and during the assault she had really long fake fingernails and one of her fingernails fell off. And so I had the detectives scour the basement where they were supposed to be and trying to find this long green fingernail to help corroborate that she was there and maybe something forceful happened that led her to lose that fingernail. It can be really small. When we're looking for that substantiation or that corroboration, that can really be impacted by a delayed report. And most of our cases are delayed. when we have a delayed report, we're looking for why a person chose to disclose at that time. And we see a lot of delayed reports in cases where a minor is the victim. Something might be that the offender is finally out of the house. Say mom's boyfriend was the offender and they finally broke up. So child finally feels safe enough to say, Mom, this has been going on. I had a case, and I think Brett, we talked about it when we were going over this, where I had a victim not disclose until the offender was finally all the way in prison. He traveled for work, he was gone regularly. He finally went to prison for an unrelated offense, and she finally felt safe enough to tell Mom, this has been going on for years. And so we're looking at that sort of thing for the reason for the disclosure at the time. Another common situation we run into as prosecutors is maybe the offender has an age preference and our current victim is getting too old for the offender, and maybe they're moving on to a younger sibling or someone else. And the victim will speak up and say, look, I don't want this to happen to anyone else. And he told me that he's going to start, or I've seen him start doing the same things to younger sister that he's done to me for all of these years. We look at issues with evidence collection. We look at to make sure that procedures were followed, whether a warrant was obtained if that's necessary, whether the right documentation occurred. We look at chain of custody issues, making sure that that piece of evidence was tracked all along the process, and so we can show where it went and who it went to and who touched it at all times. And a lot of times too, these cases are just inherently messy, especially with a juvenile or a minor victim. Maybe there's a disclosure because the parents are divorcing. And we just have to be aware of all of these external potential motivators for disclosure, whether it's positive or negative, and be able to give the jury an explanation about why things are happening and what it means for the case.
All right, so as Celine just said, issues with evidence collection are something that we have to really take into consideration when it comes to charging considerations. Two of those are search and seizure and Miranda. Search and seizure is protected by the Fourth Amendment of the Constitution. It protects individuals from unreasonable searches and seizures by the government and requires a warrant based on probable cause in most situations to conduct a search. It's not required in all situations, but the rule is get a warrant unless there is one of those extenuating circumstances that would allow a search to be conducted without a warrant. I tell my law enforcement officers, if you have a question whether you need a warrant or not, get a warrant. At least at that point, a judge has made a probable cause determination and determined that a warrant is appropriate. And if that warrant's granted, any issues down the line with whether or not probable cause existed will go in favor more often than not in the favor of law enforcement, and that evidence will then be able to be used. If a warrant is either not obtained and needed to be obtained, or a warrant is obtained even though there's not probable cause, that evidence that's collected will ultimately be suppressed, and we will not be able to use that in the prosecution of the case, and that can oftentimes lead to dismissal of the case outright. So we want to make sure that all of that evidence collection was done within the bounds of the law and the Constitution, and that the Fourth Amendment was not violated in any way. Under 45.5.101 of the Montana Code Annotated, it authorizes searches and seizures of persons, object, places that may be made in evidence contraband, and persons that may be seized. Again, that has to be determined by a judge that there's probable cause to do so. And when that occurs, that warrant will be given. The other consideration here is whether Miranda was necessary. I'm sure you've all heard the Miranda warnings before, but Miranda is really only necessary if it is a custodial interrogation. So what does that mean? One, that the individual is in custody, and custody, in a general sense, is the person under arrest. But it's not just necessarily whether or not they're in handcuffs in the back of a vehicle. It's whether or not they are under arrest, or a reasonable person in that individual situation would believe that they're under arrest or not free to leave. And then the interrogation portion requires that the questions being asked are those that may elicit an incriminating response. And so if the suspect is just being asked general questions, what's your name, where do you live, those sorts of things, those questions are not going to be asked to elicit an incriminating response, or shouldn't. And so Miranda is not going to apply in those situations. Now, when we're dealing with a suspect of a sex crime that's being interviewed by law enforcement, Miranda should just be given immediately. That way there's no questions after the fact. Miranda allows the individual to know their rights, know that they have the right to counsel, know they have the right to remain silent, and then importantly, that they have a right to withdraw their consent if given at any time during that custodial interrogation. So even if they waive their Miranda rights and agree to speak with law enforcement, they need to know that they can withdraw that consent at any time, stop that interview. And if that's done, law enforcement has to stop asking questions immediately. If those Miranda warnings are not given and the court later determines that they should have been given, any statements given by that suspect can be suppressed. And again, we won't be able to use those as evidence in the criminal prosecution of the case. And so whether or not there are any issues with search and seizure or Miranda that may lead to suppression of any of the evidence in the case that may be necessary to prove any element of the crimes charged, is a major consideration that we have to take in when determining whether or not we can ultimately prove this case, which leads us into our burden of proof that Celine will be talking about.
So burden of proof, I'm sure most people have heard that. I'm going to talk about 4 of them in the legal world here. First one is beyond a reasonable doubt. That's what the state has to prove at trial. We have to prove every element of each offense beyond a reasonable doubt. It's not beyond all doubt or beyond a shadow of a doubt, because nothing in this world is 100%, right? You might have even witnessed something and not be 100% sure of exactly what you saw. And so that's a really important consideration. It is the highest burden under the law. It's something that we as prosecutors do not take lightly when we bring a case, and that'll transition into kind of what I'm talking about next. And it makes sense, right? Because we have to be, or a jury has to be very, very, very sure that something happened, something criminal happened before we take away someone's liberties, before we take away someone's livelihood, before we incarcerate someone, whatever the case may be. We talk about in jury selection and in our jury instructions that proof beyond a reasonable doubt is proof of such a convincing character that you would base your most important life decisions on it. It is something, there are a lot of examples that we hear to try to put this in perspective for a potential juror. It might be buying a house, it might be buying a car, it might be getting married. We've heard taking a loved one off life support. It's a really, really high decision. But the really important thing when you think about this is it's still an achievable standard, right? It's not beyond all doubt, it's beyond a reasonable doubt. So you can have doubts as a juror to convict someone. It just can't be a reasonable doubt as to whether or not this offense occurred. The next one, and these are going in order from highest burden to lowest burden. Clear and convincing evidence that's typically not used in a criminal proceeding. Those are mainly used in dependent neglect cases, child abuse type situations where maybe a child is being removed from a parent. And And that means highly probable, or substantially more likely to be true than false. Preponderance of the evidence is a civil standard generally. There are a few instances where we use it in the criminal world, and it just means more likely than not. You know, greater than 50%, whether that's more a feather more or, you know, a brick. It's just over 50% more likely than not. And probable cause is one of the lowest standards that we as prosecutors and attorneys generally deal with. Probable cause is a reasonable belief that something occurred. And when you hear probable cause, you'll hear it like Brett was talking about in terms of a search warrant. A search warrant has to be justified by probable cause that an offense occurred. An arrest is based on probable cause with law enforcement. And it's also our standard for charging. But there's an important caveat when you get into charging and our ethical considerations, which we're going to be talking about next. Prosecutors have a unique role in our legal system. We as prosecutors don't technically have clients. We represent the state or the government, or, you know, however we're situated within the criminal justice system, whether you're a city prosecutor or a county prosecutor or an attorney general or a federal prosecutor. So we have very specific ethical obligations that are separate and distinct from general ethical considerations that a typical attorney-client relationship would have. And Rule 3.8 of the Montana Rules of Professional Conduct say that a prosecutor cannot ethically charge if we do not believe we can prove the case beyond a reasonable doubt. And that's where that important distinction comes in. We only have to have probable cause to file charges, but we cannot charge a case unless we believe we can prove it at that highest burden under the law. And the reason for that is the ability to bring charges to potentially impact someone's liberty, as Jordan was saying, to, you know, this is one of those rare circumstances where, you know, maybe somebody's due process rights have to go through and then they're actually taken away, you know, their rights are taken away at the end of it. It's a huge power to be able to charge someone and potentially change their life, whether you get a conviction or you don't, right? Most of these cases have a ton of press related to them, especially in smaller communities. A person's name might be all over the paper. Rumors are starting to be spread. And prosecutors need to recognize that power and that impact that a decision can have on the victims, on law enforcement, and on the potential defendant. When we're looking at whether or not we can prove a case beyond a reasonable doubt, when we're looking at this ethical obligation, it doesn't mean that we as prosecutors have to take only the slam dunk cases, right? We can have conflicting evidence, we can have contrary witnesses. And the way that I've always looked at it is, would a good jury on a good day convict under these facts? And it's something that really takes time, and have going through some of these cases to understand what those guardrails are for you individually on your ethical obligations there, or at least it was for me. I know as I'm going into my 10th year as a prosecutor. For a lot of times I thought that it was that slam dunk, had to have it all kind of case. It morphs as you spend more and more time in the system, and you know now what a jury might look at and what they might look at with distrust. The other thing about this ethical obligation is it's a snapshot in time. So it's what you have at the time of charging. It's what you have every time a new piece of evidence comes in, you need to reevaluate your ethical obligation at each and every step of the case, at each and every change, to make sure that you are still following that obligation there. And it's one of the reasons why, at least in my perspective as a prosecutor, it's really important to wait until you have as much of the evidence as possible, balancing those safety considerations for your victim. because this is something that can change with one piece of evidence that comes in, and whether or not you can ethically go forward on a case.
And if I would just say on that as well, that those are whether or not we can prove a case beyond a reasonable doubt versus whether we can charge by probable cause lead to some of the most difficult decisions that we have to make as prosecutors, and some of the most difficult conversations we have that we have to have with law enforcement, with victims about these cases. Because as Celine said, probable cause is such an incredibly low standard. Just because we can charge a case, because we have probable cause, does not ultimately mean we can prove it beyond a reasonable doubt. And sometimes there are just cases where the evidence just simply isn't there, regardless whether or not you believe without a doubt that a crime occurred. Whether or not we can prove that beyond a reasonable doubt is a different question, and such a much higher standard that that consideration is one that we take to heart and have very difficult conversations. And the cases that we're not able to charge, even though we know we have probable cause, when we don't believe we can prove it beyond a reasonable doubt, tend to be, at least in my experience, the cases that keep you up at night and stick with you after the fact, because ultimately we want to serve justice. But unfortunately, sometimes justice means us not charging a case. And so that can be very difficult for prosecutors. All right. So let's talk about some of the different charges that we are typically considering in the realm of sex cases. Sexual assault is a misdemeanor offense. It's under 45-5502. And that means that the person knowingly subjected another person to sexual contact without the consent of the victim. It's a misdemeanor offense and has less than a year in prison attached to it. The next one is sexual intercourse without consent under 45-5503. That's typically what in regular parlance is known as rape. And that essentially is the person knowingly had sexual intercourse with another person without their consent. That can either be that they did not give consent, or they're incapable of consent. Whether or not they're incapable of consent could be due to age, could be due to mental capacity, could be due to extreme intoxication. There are a number of different ways that an individual can be incapable of giving consent. And sexual intercourse without consent requires the entering essentially of the orifice of one person with either the body member or a tool by the other person. This is a felony offense. There are increased penalties based on the age of the victim, as well as the difference in age between the victim and the defendant in the case. Essentially, the younger the victim is, the older the perpetrator is, the higher those potential penalties will be. There's a distinction for whether or not the victim is under 16 years of age and the defendant is 4 or more years older. That would require a prison sentence of not less than 4 years, more than 100. If the victim is less than 12 years of age at the time of the offense, that requires punishment in the state prison for a term of 100 years. And most importantly, if the victim is under the age of 12, that's going to require that the first 25 years of that sentence cannot be suspended or deferred. And so essentially, the individual will have to serve that first 25 years in prison if the victim is under 12 years of age at the time of the offense. Aggravated sexual intercourse without consent is the same elements as sexual intercourse without consent under 503. Aggravated is under 45-5508. The main distinguishing factor here is that the person has to use force in committing the offense, but the non-consent or incapable of giving consent still applies just as it does in the regular sexual intercourse without consent. But it has this added element of the use of force. If force is used, that's going to fall within aggravated sexual intercourse without consent. And that, again, has increased penalties. The last one that we're going to talk about is incest. That's under 45.5507. And that is whether the person knowingly marries, cohabitates, or has sexual intercourse with or sexual contact with a list of individuals that are considered to be family, ancestor, descendant, brother, sister, niece, nephew, stepdaughter, stepson. And so if any of those crimes that we previously discussed occur and the defendant and victim fall within that category and that list, then that's going to be considered incest. And that has its own penalties separate and above whatever the underlying crime may be. Those are, in my experience, the most difficult cases. Not necessarily most difficult to prosecute, but just most difficult to deal with, and are the ones that, in my experience, have stuck with me the longest. Anytime that there's a sex crime going on within a family, those are very tough cases, tough ones to deal with. As Celine said, when it comes to each of these charges, as new evidence comes in, we have to reconsider whatever charge we have at that point based on that new evidence. And so as new evidence comes in, we may have a sexual assault initially charged. We may need to amend that to a sexual intercourse without consent, or the other way around. And so based on that new evidence coming in, we have to take that into consideration under Rule 3.8 and determine whether or not we can prove what we currently have charged, given the new evidence. And that could mean that we need to amend the charges. That means sometimes we have to dismiss the case outright, or we may need to add additional charges. And so we need to consider that at every stage of the case, given the evidence as that new evidence comes in. Anything else on that, Celine?
I don't think so.
Okay.
So at this point, we as prosecutors have gone through this analysis. We've looked at the evidence. We've come to a determination as to whether or not we're going to charge. The next step is the first really substantive conversation with a victim and or their family, depending on who that victim is and their age. Best practice, and these are, again, the hardest conversations, as Brett was saying. Even if you're not going to charge a case, best practice is you need to bring that person in. You need to have a conversation with them if they're willing to talk about why. And most often, not all the time, but most often, like Brett was saying, we believe that something happened, but we do not believe we can reach that beyond a reasonable doubt burden that is so high at trial. And those are the conversations that are hard. If alternatively, we decide that there is enough to bring charges, we will bring in the victim or a parent if the victim is underage. And this is all very person dependent. I had brought in older teenage victims who seem to really be understanding of the process, who want to be involved. I've had conversations alone with them sometimes, depending with parent consent, obviously, depending on how supportive the parent is. I have had younger teenage victims in to have a very high level conversation as to what the process is. It's all really fact specific and victim specific. We bring them in, we sit them down face to face, and we try again to give some autonomy here if we can, recognizing that our job as prosecutors is to hold people accountable, is to protect the public. I generally have a philosophy that I don't want to do more harm than good. And so if a criminal prosecution is going to put a particularly vulnerable victim into a state of distress, if there's a risk of self-harm or something like that. Obviously that needs to be articulated to me. That's not something that I decide on my own, because that's not my job to decide what sort of feeling somebody might have about it. But that's my philosophy, is generally not to do more harm than good, and that's a continuing reevaluation as the case goes on. A lot of child victim cases, my general philosophy again is to charge and continue to evaluate as the case goes on, because someone preying on a child is a particularly vulnerable victim, and that's is a public safety risk that we as prosecutors need to be aware of. After that, the big question is, are they willing to testify? Jordan alluded to this in the very beginning. There is a right to confrontation. Defendant has the right to personally confront anyone bringing charges against them or any witnesses. And so in Montana, that is a very, very strong consideration. Every person who's going to bring anything into this case has to personally testify, be on that stand in front of a jury, and be cross-examined. We have tried to expand that a little bit with COVID and that sort of thing, to have online or remote testimony. That has almost always been shot down, even under COVID circumstances in some cases, because that right to confrontation in Montana is so incredibly important. We talk about the timeline, and Jordan, Aldina, Brett, feel free to chime in here. I almost always tell my victims that this case will not resolve within a year, and most often they take longer than that. I think I've had a sex case go on for over 2 years at one point. These are difficult cases. There's lots of legal issues that come up. And so I generally tell my victims that the wheels of justice turn slowly, and to have that expectation going in. And then, just like we are going to do coming up next, for you all, we talk about the process and all of the different hearings and things that might come up, so that they have an expectation and understand what we're doing as this time is going on. Because there are times where there's a lot going on in a particular case, and then there's times of, pretty quiet, nothing's really going on because maybe an issue's in front of a judge for decision or something like that. The other thing that I will generally do in a meeting like this, my first question is always, what questions do you have for me? Because I want to know what the primary concern is and what's sticking out in their mind, so that I can take care to answer that question and, calm any fears that they have to the best of my ability. And as the case goes on, like Brett was saying, we attempt to honor the level of communication that any given victim wants, whether that's regular, weekly, every other week check-ins, whether that's, only when something super substantive happens, or, I don't want you to call me unless this case is actually going to trial. And depending on what's going on, we do our best to honor that.
And I would just say that the one part that Celine just talked about, whether they're willing to testify, whether they're willing to testify or even able to testify, has to be a consideration when considering whether or not we're even going to charge the case as well. As she said, every person has to testify before a jury and be confronted with cross-examination. And so, even sometimes if they're willing to testify, meeting with that individual, or watching their interviews, they just may not be able to testify. Some people just aren't able to talk about this stuff, and they have to be able to talk about it in a way that the jury can understand, and ultimately make the determine whether or not a crime committed here or was committed here. So that's a consideration at the charging portion as well.
I'm wondering if we want to take a pause. Two things. One, it might be a good time to take a brief break, but before we do so, I want to offer the opportunity to just say out loud to the committee, is there anybody who has any questions at this time? You know, the presentations today may be among some of the most technical, and while the nursing presentation and the law enforcement presentations were technical too, the language of the criminal justice system may be the least familiar to the most of us. And so, does anybody have any questions at this time before we move forward? Okay, well, let's take a 7-minute break or 9-minute break and come back at 9:25. So it's an even Steven number. And we'll come back at 9:25 and continue then with getting into the proceedings of the court cases. All right, we'll come back together here. Restart the screen share. Anybody have any reflections on the break where you have a quick question before we get going again?
Okay. So we are now going to start talking about the process after charges have been filed and what that looks like. And one of the things that you know, if you prosecute or are a defense attorney and you go into different jurisdictions, is every judge in every jurisdiction does something a little bit differently. And sometimes it's really, really different. You're dealing with totally different timelines, you're dealing with different procedures, you're dealing with procedures being out of the expected order. And so what we tried to do today is give you kind of the overall big picture of what most judges around the state do in terms of the proceedings and the order they go in, but caveat that everyone is different and you need to learn the local rules and what's going on in every specific court you're in.
All right, so we've already talked about this quite a bit, but with regards to victim contact, we try to contact them at all stages of the case, but again, giving deference to their willingness to have contact or want to have contact. So one important thing that goes throughout this case is the state's discovery obligations, and it's at the end of the slide here, but I think it comes up even beforehand once a case is charged. So under 46-15-322, the prosecution has an obligation to disclose all the evidence that's within the state's possession to the defense. That can be names and addresses and statements of people that may be called to testify, any oral or written statements, any reports. They're allowed to see any physical evidence that we may have. And so that obligation sticks with us throughout the entirety of the case. So if at any point during the case the state comes into possession of additional evidence, that evidence has to be turned over to the defense. Under subsection E, and this is one of the most important parts, is that all material or information that tends to mitigate or negate the defendant's guilt of the offense charged has to be sent to the defense as well. So it doesn't matter whether the evidence is good for the prosecution's case or bad for the prosecution's case. That responsibility under 46-15-322 sticks with us through the entirety of the case. And regardless what that evidence is, the state has an obligation to turn that evidence over to the defense. And so that can be from the time we charge the case up until the date of sentence. I've had a case where we were at trial, and in the middle of trial, some new evidence came in. So we had to disclose that to the defense. We had to have a hearing on it to determine whether or not that evidence could be utilized at trial or not. And so that's an important thing to keep in mind when it comes to evidence. So once we charge a case, the individual suspect or defendant can either be subject to arrest or a summons. In a sex case, especially a felony sex case, more often than not, that will be done by an arrest. We'll request an arrest warrant when we file our information in the case and have that individual arrested. They will be given bond, as every defendant in the state of Montana is entitled to a bond of some sort in the criminal case, unless it's in a death penalty case. And so in these sorts of offenses, they will be given bond. That's something that can be argued for by the defense to have lowered. But typically in these sorts of cases, that occurs. If they're not arrested, we can seek what's called a summons. That's essentially an order from the court telling the defendant the date and time they need to appear in court if they're not arrested on the charge. And so they can either be It could either be custodial, where they're in jail at the time of the hearings, or non-custodial, in which case they've either been summoned to court, got an owner cognizance release in which they're released without having to post bail, or possibly that they've posted bail at that time. The first hearing is an initial appearance and or arraignment. Lots of times the initial appearance and arraignment are done at the same time. But like Celine said, every court's different, so every court does it slightly differently. At the initial appearance, the defendant will be read the alleged charges against them, the allegations within that charge, and then the possible potential penalties of each charge alleged against them. At the arraignment, they will then either plead guilty or not guilty to the alleged charges. The vast majority of the time, defendants will plead not guilty at the arraignment. That then gives their counsel the opportunity to go over the discovery and then discuss both the strengths and weaknesses of the state's case as well as the defendant's case based on the discovery that's been received at that time. And then ultimately, I'm sure as Eldina and Jordan will talk about, make the determination whether or not they want to go to trial or try to enter into plea negotiations with the state. And I already talked about the state's discovery obligations that stick with the state throughout the entirety of the case.
Okay, so I'm next, and we're going to start talking about the defense process. A couple of things you will notice from me is I use the term alleged victim, and I also use the term client. I don't call my clients defendants because that's what they are. They are my clients. The defense process starts at the initial appearance. So the initial appearance is actually, there can be two parts to it. Like Brett said, they generally do them, they can do them at the same time if it's because the felony, if it's a felony. So with the initial appearance, usually that's a lower court judge, like a justice of the peace, who reads the person their rights, lets them know what they're being charged with, and sets a bond amount if the bond amount is not already set by the district court document. At that time, generally, justice of the peace or whichever judge is handling that will ask whether or not they want to be appointed a public defender. As Jordan mentioned at the very beginning of this talk, our constitutional rights are protected. People are entitled to be represented by counsel. That entitlement has a couple of limitations in the state of Montana and just about every place else. One, you are entitled to be represented by counsel. You do not have to have a public defender. You can hire private counsel. Hiring private counsel, folks should never be surprised. I have been both a private attorney and a public service attorney. I am currently a public service attorney. You should expect that if you go to hire private counsel, that they will ask you for a retainer. I generally tell folks when they're going out to find private counsel, which anyone is entitled to do, retainers run anywhere from $10,000 to $20,000, depending, and that is a sum that you have to set down first, and then your attorney will start working through the process. Folks get they have a lot of feelings about retainers, but I will say to you, nobody's ever really happy. It's like a divorce. Nobody's ever really happy with how this comes out. And you can get all the way to an end of a case, and then somebody will fire you and say, I don't want that, and I'm not going to pay for that. I could have gotten anybody to do that. So there's some sticker shock, but folks should not be they should not be surprised by the amount of a retainer. Or you can be appointed a public defender. The public defender has offices all across. Oh, I have a question. No, the public defender has. We have offices all across the state of Montana. We have 3 different divisions. One is what we call the trial division, one is the appellate division, and one is the conflict defender division, which is the division I run. The only real difference between the trial division and the conflict division is that I handle conflicts. So if there are two defendants in a case or two clients in a case, my office might take one and the trial division might take one. But we're all trial level attorneys. You must qualify for the public defender services. We request that people turn in information to make sure that you actually do qualify. All of the public defender determinations and information is in statute. So you can see it's 47-1-104, which is the public defender in the Montana Code annotated. And that is what gives us, and it also clarifies what kind of cases we can handle. So we can handle misdemeanors, we can handle felony cases of all kinds. There are some special qualifications you have to have in order to handle death penalty cases, which are very rare in the state of Montana. We handle abuse and neglect cases, which sometimes also come out of these kinds of charges. We handle guardianships and mental health commitments. So the public defenders do all sorts of things, but that is the beginning of the process. You have to have counsel. Now, getting further into this, and there are times when clients will say, I don't want you to represent me. I don't like you. You don't get to pick your counsel. You get to have counsel. So there's a difference. And we've been standby counsel. We always advise folks not to do that, but it happens. So that is the beginning of the process. And once we are appointed by the court, we start moving on a case. Next slide. Okay, so the defense process, right? If I'm appointed and I have a new client and they're in jail, I'm going to go over and meet. We have standards where we want our attorneys to meet with the clients as soon as possible, at least within, a few days before the next court hearing. When I meet with that client, I'm going to talk about bail or bond, as you want to call it. There's a common misconception that bail is to be punitive, right? If a case comes in and it's a terrible case, they should have no bond. As Brett also said earlier, people are guaranteed bond and guaranteed the right to be released. There are judges who will set bond extremely high punitively. But the things we're looking for are, do you have connections to the community? Is there a certain amount of bond you can put forward? Do you have any charges or any previous interactions that might signal that you're not going to return to court? Bail is an enticement to show that you are going to show up for every court hearing. It is not meant to do really anything else. It can, people will justify bail by saying it's, it protects the community. But really, if you look at what bail is supposed to do, it is supposed to guarantee that a person will return to court when requested. So there are times when people get an own recognizance release, which just means this person will return to court for the next hearing. People will say, well, they don't have any bail. Well, they do actually. The bail set is their own recognizance, that their own guarantee from themselves says that they will come to court. And there are always conditions when somebody is, whether they post a money bond or, you can go through a bail bondsman. You can, which if your bond is $500,000, you will post a percentage of that money to a bondsman. You don't get that money back when the case is over. But there's always conditions. Generally, the conditions are you cannot have any contact with the victim or you cannot have any third-party contact. So you don't want, the idea of third-party contact is, I tell my sister to tell somebody to tell the alleged victim in this case, like, you better take that back or something. So there's always conditions. Violation of those conditions, which we set out very clearly with our clients, can have them back in jail. It can have additional charges. So if somebody doesn't show up for court and a warrant goes out for their arrest, they can be charged with bail jumping, which is another felony that just gets stacked on. They can be charged with tampering, which is tampering with a witness through that third party contact. So when meeting with a client, we very clearly lay out, this is what you should expect. Here, I'm going to ask for a bond reduction. I can't guarantee that. Do you have a job? Do you have ties to the community? I take into consideration where the alleged victim is and how, we're going to navigate that. And then I have to let the client know and make sure that they truly understand the charges against them and all of the possible penalties. It is a difficult thing to say to somebody. The possible penalties of this case are a minimum of 25 years in the Montana State Prison and a maximum of 100 years in the Montana State Prison. So all of these cases, and I don't think anybody ever downplays that, but they all have very serious consequences. So I appreciate what Celine and Brett said about the seriousness of charging someone if you aren't sure that you can meet the burden, because we all know when it hits the newspaper and people hear, oh, wow, that person was charged with this. When that case goes away, nobody ever issues a retraction. There's no front page story saying something happened in the justice system and that case was dismissed. People get marked for life. If folks are in jail, the collateral consequences of losing their homes, their jobs, all of the things that come in with unemployment or being marked in such a way, they have longstanding consequences. And so this is a very, very serious, it's a very serious role for all of us. So we talk about the charges and the possible penalties. We talk about the substitution of judges. All judges have different stances on how they handle cases. There certainly are, I can't even think of the right word, but there are judges that I would not want to sit on these cases that I don't believe can be fair. So we have the right under the Montana Code annotated to sub a judge for no cause within 10 days of an arraignment. And I have done that. Other people have done that in the practice, but there are judges. I mean, you don't have to do that. But it is an option after you miss that 10-day window. And so if I want to sub this judge and the judge we get in the next poll is somebody that Celine doesn't think can do a fair job, the prosecution also has the ability to sub a judge. Those are things that have to happen very, very quickly. Arraignment has to happen very quickly for folks who are in jail. So they usually get set for the next hearing date, depending on which jurisdiction you're in. That might be next week, or that might be tomorrow, depending on which judge you have. So the first part of the process moves very quickly. When I meet with a client, we also talk about assessments. I have to make sure that I believe that my client is fit to proceed. Fit to proceed means that they have the mental capacity to assist with their defense, that they understand the proceedings against them. And it's really a 3-part test. We have clients who are not fit to proceed. That's a whole, and then they have to go to the state. We have to get an evaluation. They might have to go to the state hospital. But all of those things have to be taken into consideration, and we have to act on them. If I don't believe a client is fit to proceed, a client cannot be arraigned because they cannot knowingly enter a not guilty plea. We also make a determination or try to have a conversation about whether or not alcohol or drugs are an issue for this client. If maybe they were an issue in the interaction, and we might get them a chemical dependency evaluation. I also talked to a client about the potential investigation and how this goes. They tell me about their experience about what has happened first, right? There might have been a subpoena to get their DNA. They may have already talked to an officer. Generally, when they are arrested, there is a request to talk with an officer. That's when the Miranda comes into play, and they can choose not to. Choosing not to talk to an investigator at the time of arrest or any other time is not a signal of guilt. There are a lot of people who are very afraid of the process I wouldn't talk to an investigator. I'm an attorney and I know how the process can work, but we all have to make those decisions. And in that situation, people have to make the decision under very high duress. Celine, I think, mentioned earlier the timeline. I tell a client that this will take no less than a year. Any kind of sex case in my legal experience has not taken me, it's not something that gets done quickly. And while it might feel like it should, again, the price is very high for everybody. And so all the sides need to make sure that they're doing the most that they possibly can to make sure everything is in line. One of the issues that we come up with in the defense process is how families can and cannot be involved. I've represented children in the Youth Court Act, under the Youth Court Act, who are accused of sexual assault. Their parents want to talk to me. They want to know all about the case. And I will say no. Why? Because the parents aren't my clients. I solidly protect the attorney-client privilege. And if I enter a third party into that who is not part of my firm, I then can violate the attorney-client privilege. Nothing is privileged anymore. Somebody might go out, spread the information that I've shared with them, or talk to somebody else about it. And the next thing you know, we have just a gigantic mess where, and again, this is all like the high level, so I'm not saying it always happens, but parents want to know. Clients may not talk to me in the same way that they would talk to me if their parents weren't here, if their parents weren't in the room. And I think we all want to get to some resolution. And so I generally keep people's families out of it. I let my clients know they can share what they want to with their families, but I'm not going to do that. I also really encourage people never to talk about anything on the telephones, right? The jail telephones are recorded. So in the beginning, there's a long spiel and a meeting that we have with the clients. If the clients are out of custody, we still have that meeting. We still tell them all of these things. It's just not at the jail. We also tell them, like, here are the things you cannot do. Sometimes they're on GPS to make sure that they didn't go, to make sure that they're staying away from wherever they're not supposed to be. So that's the start of all of it. And really, we get to a place where the start is your client enters a plea of not guilty at the arraignment, and then we move forward. I can also just tell you that when we get to this process of talking about bail, going to the arraignment, I generally don't have any more discovery. I don't have any of the reports. I don't have anything more than the charging document that the county attorney or the state has filed against my client. So I have very, very limited information, and I make no judgments other than some tactical ones to start. Okay.
Aldina, can you just talk about why you don't have discovery generally at an arraignment? I mean,
well,
generally the process is just starting. It might be the first time you file your notice of appearance, or prosecutors know who specifically is going to be representing the client, right? It's just kind of the start of the process, and then that starts the discovery process for you to go into your deep dive of the case, right?
Right. So when I get an appointment from the court, again, I have the client's name, I have the client's charges, and then we'll get the information, which we call the charging documents. But the county attorneys or the state are not just going to put all of that information out there for anybody. They want to know who the attorney is before they hand that, what we're calling discovery, over. So when I file a notice of appearance, or in our case for the public defender, we file what's called a notice of assignment. That usually includes a discovery request. So we're asking, the agreement between the attorneys is, I'm going to turn over everything I have to you that I need to, and you're going to turn over everything that you need to, but we still have to document the request. And so we file a motion for discovery. And sometimes the discovery doesn't come to us for 30 days after the arraignment. It's just part of the process. So that's why I'm saying that I work with very limited information in the very beginning.
Eldina, I'm just gonna step in here. We did have a hand go up earlier. It's down now, but Detective Gutarian, did you have a question that you wanted to ask?
Yeah,
Or was it?
you kind of touched on it a little bit. One of the questions that I get quite frequently is how bond works and like where money goes. And I guess like when they don't get their money back, if you can just touch on that a little bit more.
So, if you use a bondsman, the money goes to the bondsman, right? The bondsman is actually putting up the bond for you, the larger amount of the bond for you. So, they're taking a risk, and then you give them the percentage. I think it's 10% maybe, of the bond that is requested. You don't get the money back that you give to a bail bonds person. That money's gone. If you were to post a bond, if your bond is $1,000 and you turn in the $1,000 to the sheriff's office or whoever is holding the bond, at the end of your case, you cannot get it back until the case is all resolved. At the end of your case, we've filed requests for bonds to be returned because they fulfill their obligation, right? The obligation is the client will appear at every court hearing that they are required to be at. And I say that because there are hearings that they don't have to be at if we can cover, as the attorneys, the information for them. So with a bonds person, if you put up $5,000 to cover the $50,000 bond, you will not get that $5,000 back. And a lot of the time, bond, bail, it's not protecting the community. It is a putative, move against poor people. So the folks who are sitting in jail are poor because they cannot post a bond. If you are of means and you can post that bond, you're out. And you may or may not have gotten a different type of release. So without too much social commentary, the folks who are sitting in jail, it's because they can't post a bond, and it's because they're poor, and they're only getting more poor because they're sitting in jail for very extended periods of time. If you look at any county jail right now and their jail rosters are up, you'll see folks who have been sitting in jail for 450 days or somewhere around there, a year and a half in jail because they can't post bond. Or, I mean, sometimes there's other kinds of holds, but generally it's that. So money not coming back to you is because it went to a bonds person who posted the larger bond for you. You're paying for their services and you won't get that money back. Did that answer it?
Yeah, does the money just go to the courts or who actually like gets the money?
I'm trying to think because I rarely have folks who post the bond. I believe the bond. Jordan, can you think of where it goes?
The court holds the money.
So it goes with the clerk of court usually.
Right.
Yeah. So it goes with the clerk of court. I mean, the clerk of court probably isn't going to take a personal check on a large bond. But they may take a cashier's check. They may take something that shows that there's actual money behind it. Rarely used in Montana, but available is a property bond where you can leverage bond against a property to cover that. I think those are always risky and they're difficult to accomplish. So I haven't ever had to, I know property bonds exist, but I haven't ever had to help a client get one.
Awesome, thank you.
Yep. Any other questions before I move on to the process? Okay.
Can I jump in real quick, Eldina?
Yeah.
I was just gonna say that when it comes to bond considerations, 469301 lists the considerations to be made when determining amount of bond. And number one, as Eldina said, is to ensure their presence at a criminal proceeding. But there's a list of other considerations, to protect persons from bodily injury, can't be oppressive, ensure they can comply with their conditions, commensurate with the nature of the offense charged, and then the remainder of them basically are, you know, family ties, how long they've been in the community, things like that, to ensure that they're going to show up for court. And so if people are curious about that, those considerations are in 46.9.301.
I think the part that is most difficult to argue is that it's oppressive, right? I mean, bond tends to have a lot of feelings behind it. And again, it is to ensure people show up. It is to protect the community. But there are factors that can be weighed to make those things happen. And generally, you know, really high bonds are meant to be oppressive. They're meant to hold somebody in jail so that they can't get out. Otherwise, and they can just be, they can be lowered or they can be made higher. So the trick about a bond argument is I can go in and say like, hey, can you do this? This is all the information I can give you, Your Honor. And the county attorneys tend to have way more information than I do. And so I might be, you know, just trying to wing a little bit of an argument, and a county attorney can come back and say, well, I have all this other information and I've had judges make them bond higher. So everything is a little bit of a risk when we're trying to make some of these arguments, because as I've said, I don't have a criminal history. I don't have anything but that charging document yet. Okay.
Yeah, I think that's true. I was just going to say too, though, that you can also make that bond argument at any time throughout the case, right? So if later you get more information, you can always bring that back up with the court too. And we have that happen quite a bit, where obviously more information's come to light. You know, that helps the defendant, you know, be able to make a little bit better argument as time goes on as well.
Right. And we've also had, you know, when I think the unfortunate part about the bond process right now is that everything costs money. And so if you want people on a drug patch, that costs money. If you want people on a SCRAM, which is an alcohol monitoring program, that costs money. All of the things that would allow people to protect their liberty and continue to work or parent their children or whatever it is through this process, they all take money. So it is, and there are some places where there are grants, there are some places that have different programs, but it can be very cost prohibitive. And sometimes when folks just want out, their grandma's the one who's going to post that money to get them out, but also the one who's going to be paying for their drug patch or their SCRAM or whatever. And when a case can take a year, it's a lot of money that is going into this. So yes, and like Brett said, we can always come back and ask, but a lot of judges will say what's changed, and we have to be able to show that something has changed, or we have new information, or maybe we got a CD eval and we can get them into treatment, or whatever that is. It really depends on the person. It depends on the circumstances of the case, and every one of these cases is different. Even if you align 5 basic facts, every single case is different. So, okay, going on to the process. Let's say we've done the arraignment. You know, we've been appointed. The client knows about their rights. They know about my expectations. I have reviewed or received the discovery. In discovery is everything that every one of you on this call has compiled. So I'm the last stop with everything. You might have done one part of it. Somebody else might have grabbed another part of it. The state has a duty to give me everything that is pertinent to this. But that doesn't mean that the alleged victim's name is in the report. Generally, it's in there using initials, and I will have to call and find out who it is. Like, we do things still to protect, or things are still protected when they get to me. So there's still more I have to do. It's my duty to review every single piece of evidence there is. I can't do my job without that information. So I watch every video. I read every report. Including the medical, the police reports, anything, if there's DNA, And things trickle in. I think that's also, you know, the DNA results might not be there immediately with that. Some places do bring everything together before they charge, but also like Celine and Brett have talked about, statute of limitations might require something to get filed right now, and we will deal with it as it comes in. My job though is to look at all of this discovery. My job is to synthesize that discovery and see if there's anything missing. Is there, and in that I'll say, and we'll get to motions in a minute, but I'll be like, hey, Brett, I don't have the report that goes with the first step interview, right? Or I don't have this. And he can say, well, I don't have it yet. I'll get it to you as soon as I can. Or, oh, I didn't, you know, or I might read a report and say, it says that there's another report here, or there should be another report from a different officer. Does that exist? Sometimes things actually just don't exist, even though maybe they should, or you think they should. So it's my job to make sure I have everything and I know as much as I possibly can. I like to do that before I start. I have a motto that says, know what you have before you play. So I don't talk about negotiations. I don't make a determination. I don't make assumptions. I view whatever it is that I have in front of me, see what I might be missing, talk to my client. My client is entitled to see everything that's there. My client is entitled to watch that first step interview, to see the medical records that I get. That person's liberty is at risk. And so I make sure that the clients see it. From then, I might determine that I need to have some witness interviews. I usually work with an investigator. I have an in-house investigator. Almost all of the public defender offices do. We also have investigators that we use on contract. And that investigator and I generally go do witness interviews. And we tell the client, this is what we got out of this interview. One interview might spark the need for another interview. We might get information and go, whoa, I don't think we want this information, and back away from it. So the investigatory process can be very long for us, tracking folks down who don't want to talk about things. I think you all understand the idea that people don't want to get involved, no matter how serious, because they may feel like there are repercussions. So once we get as much information as we can, we may start making motions. And motions are filings that we make with the court. I'm going to file a motion. We'll start with a motion to suppress. A motion to suppress may mean that we think evidence was gathered illegally or inappropriately, I guess I'll say, and we don't think that a jury should be able to see that. I'll file a motion. Celine and Brett have the opportunity to respond to my motion. I may get one more reply, and we may have to have a hearing on that. So if you can imagine, that's just that one motion, and without an expedited schedule, can be a 2-month process, a 1.5-month process, depending on the jurisdiction you're in, before we get an answer. That's part of why this process can take so long, is we have a lot of work to do between the two teams while we're going through this. The next thing is a motion in limine. Motions in limine are intended to request a court to exclude or limit evidence so that it also cannot come out at trial. And generally it's about like something that's prejudicial, something that we don't think is relevant, or something that we also think might just be inadmissible. We also use motions in limine to limit or exclude expert testimony. So, you know, one basic thing, and depending on who you are and what your belief is, sometimes we file a motion in limine to require that the state not call us public defenders, because there is a prejudice that public defenders mean that somebody can't afford, quote unquote, a real attorney, or whatever else. There's other people in my agency who are proud to be public defenders and never file that motion. so there are different things in motion and limine. There's some like typical things that we do, but there are other atypical things. Like, I don't think your expert is qualified, so we're gonna limit the scope of what they can testify to using a motion and limine. The next motion would be like a motion to compel, and these don't all happen in the succession. These are just potentially opportunities that happen somewhere in the process before trial. A motion to compel is, hey, Brett, I see that there's this report. Can I have it? He doesn't have it yet. I asked him 10 times. He's still waiting on it, whatever it is. At some point, we're butting up against deadlines, and I will file a motion to compel so that the court knows I'm trying to ask for this and it hasn't come up yet. And that can also be a hearing. Motions to compel are frankly not that common depending on which jurisdiction you work in. Like, I think a lot of the defense attorneys and the state, we work together every single day. So we kind of have, we know what we need to do to get things done. A motion to sever, if there are two co-defendants, two clients, they may prosecute them together in a group, and you might not want that. So you might file a motion to sever, or sometimes things get stacked into one charging document that are separate occasions. And we might file a motion to sever those so that each of those charges is dealt with separately as to not prejudice the two things. And then a motion to modify. I think we intended this, Jordan, tell me if I'm wrong. I think we intended the motion to modify to be, we might file a motion to modify conditions of release. Maybe we want somebody's can't afford the scram anymore, and we'd like the court to take them off of it. We might file a motion to modify and ask for a hearing so that they can have their release conditions modified. Hold on, I'll take a breath. There are a few things. Ultimately, a case is always a client's case, but there are some things that are not that are not up to me as an attorney. One, it is a client's decision and right to decide whether or not they accept a plea agreement. I can get a plea agreement and think that it's great, and it would resolve the case in a way that is beneficial to the client. I can offer it to the client. It is up to them. And when a client says to me, what would you do? I can't answer that because it's not my life. I'm going home and having dinner with my family later. This may change the course of my client's life. So it is a client's decision whether or not to accept a plea agreement. The other absolute right of a client is to take a case to trial. We don't force clients to go to trial if they don't want to. So it is absolutely the client's decision. When a client wants to go to trial, even if we think it's not a great case, we're gonna do that because, again, it is their right. And the final right that they have is the right to testify at trial. If a client wants to testify, there are times where it's not a great idea. Excuse me, but again, it's their right. And there are other times that it is absolutely important. One of the things you'll hear us talk about a little bit when we get more to the jury trial part is that it is not indicative of guilt if a client does not testify at trial. And often there is a perception, sometimes with potential jurors, like, can you go through this whole process without having to hear from the client? The answers to that question can be very telling. But we try to reinforce that. A client never has to testify. And they, not just about not impeaching themselves, but it is up to them. So I'll just stop right there. Any other questions about that? Okay, so I think Celine, you're up next.
Yeah, so, well, Aldina and Jordan are going through their part of the process and doing the same, or doing those things that Aldina talked about. The state is also doing a lot of the same things. We're looking at all of the discovery, with a deeper lens. We're looking for legal issues. We're trying to decide if there are briefs and motions that we need to file for the same thing, like maybe Aldina or Jordan noticed up an expert and we as a state think, no, that expert doesn't get to talk on this case. They're not right for this case. So we'll file some of the same motions at the same time, and it turns into a little bit of a briefing war in these kinds of cases where things are flying back and forth and there's a lot of deadlines and we're trying to keep track of that. And a lot of those deadlines come from what we call an omnibus hearing. And when I think omnibus, I just think all of the things. These are all of the issues that we need to raise that are going to come up. We're giving the judge and the court an idea of everything we need to discuss and get answers on prior to taking this case to trial. And it's a lot of the things that Aldina talked about, the motions to suppress, the motions in limine, discovery issues, whether counts or cases are going together or not, that sort of thing. And so a lot of jurisdictions, this is one of the main places where jurisdictions do things really differently. When Jordan and I were prosecutors in Missoula, we had formal omnibus hearings. We would fill out a big long sheet of, packet of paper identifying all these issues, and then the court would go over it with the parties in court that's recorded and transcribed in the whole 9 yards. Other jurisdictions will have the judicial assistant do it. Other jurisdictions will just say, exchange the paper and file it, and the court will sign off on it. And that's one of the main things that I've seen as I've prosecuted around the state where there's a major difference. Jordan and I had a case together before I left prosecution services where the omnibus hearing almost acted as like a final pretrial. And so it was, I think it I knew it threw me off, because we had to set our own briefing deadlines and we had to address these issues before the court did. And it was just a really different process as compared to most other places. Aldina talked a lot about the issues that they might raise. Like I said, we as the state might raise a lot of the same issues as well. But there are a couple that are more prosecution driven than others. One of which is what we colloquially call the rape shield statute. Rape shield is codified in 45.5.511, and it's one of those things that is based on our right to privacy, again, in the state of Montana. And the rape shield statute provides that the sexual conduct of a victim is not to be brought up at trial unless it's to show past conduct or relationship with the potential offender or the origin of semen, pregnancy, or disease. And so we want to keep the facts of the case to the facts of the case and try not to make it a second trial as to, what sort of sexual preferences or sexual conduct our victim might have engaged in prior and or after to this offense. The other thing that we look at is what we call 404B, or it's called other bad acts evidence. And the thing about 404B that as prosecutors, you should be very, very aware of, and then there again be briefing to put guide rails on this to see how far a prosecutor might be able to go. Prior bad acts evidence cannot be brought in to show that somebody acted in a propensity type way, which means that just because they did it once before, they obviously did it again here. But some of that evidence can be brought in if it has a legitimate reason for it. So say, for example, we have an offender who has previously groomed a child around the same age as our current victim, or had previously had a sexual relationship with another child that maybe isn't charged in this case. That might be a use of 404B evidence or prior bad acts evidence to show that the offender was aware that, he had a motive or he had a pattern or he was aware of what he was doing, to go to that mental state element. And it's one of those things that I have seen can burn prosecutors, can overturn a conviction faster than anything else, is when these prior bad acts or this other acts evidence gets brought in and it's so overwhelming and so prejudicial that the jury loses focus on the facts that they're there to decide and may or may not convict on these other acts. And so it's something that really should be considered long and hard before a prosecutor decides to bring that evidence in. And it's probably, in sex cases, one of the more contested issues we deal with. And there will almost always be a hearing to put out exactly what this evidence is and how the prosecution can tie it to the case. It's got to be very, very closely tied to the specific facts to be brought in. And it's, in my view, it's kind of a landmine or a minefield, because there are just so many ways you could take it too far. So you really need to be cognizant of that. Like Aldina was saying, a lot of times prosecution too is waiting on things to come to us. There might be ongoing investigation and we're waiting for a law enforcement report. You know, we've heard that the crime lab is a little bit backed up on DNA. They're working to remedy that. So we might have made the decision to go forward and make the charging decision without that DNA evidence. So we're waiting for the official results to come in. And a lot of times at the omnibus hearing, you are supposed to discuss whether or not a plea agreement has been made. In my experience as a prosecutor, it's really difficult, like Aldina was saying, to make that even an initial offer before you have all of the evidence and before a lot of these really contested issues are decided. And so, at least in my practice, until I knew what my whole scope was, what I was going to be able to introduce, who my witnesses were going to be, I was not really interested in having really substantive plea discussions with either my victim. I'd probably bring it up and say, look, we, at least in Missoula, we had an obligation to engage in plea negotiations in every case. But I would not likely be having a substantive discussion with Aldina or Jordan or even my victim until I knew exactly what sort of field I was playing with here. Like what's listed on the slide, we'll talk a lot about the likelihood of conviction. We talk about whether our witnesses have the ability or will willingly come to testify. We look at the scope of the evidence. We'll look at the types of plea agreement. We might talk about that. And this is another place where every judge does things a little bit differently. We really have two types of plea agreements. 1B is our term for it. It just essentially means that it's binding on the court. And the court cannot go above that plea agreement, cannot sentence higher than that plea agreement recommends. Otherwise, the defendant has an ability to withdraw from the plea. Or it might be a 1C agreement, which is non-binding on the court. Aldina or Jordan or Brett or I will make our individual recommendations. We might even agree on it, but then the court will say, no, I don't agree with that, and can sentence any range the judge sees appropriate. Certain judges will only do 1B agreements and certain judges will only do 1C agreements. And so it's a really, I know as me leaving the jurisdiction where I was familiar with and my 5 judges there, switching to judges that would only do a 1C agreement, it was really challenging for me to negotiate a plea offer, because with the binding offers where, you know, maybe we give a range in it, maybe we agree upon a sentence, it's more of a sure thing, right? We know what we're going to get, or if we don't get that, what we're going to trial. And I can imagine for a defendant and a defense attorney, a 1C agreement could be really, really scary, knowing that there are no limits to what the judge could do there. Yeah. There can also be an entry of a plea without an agreement. We call that an open plea. And again, it's non-binding on the court. We make our recommendations. Those are kind of rare in my experience in these. I think I know myself, and I won't speak for Aldina or Jordan, I like to know at least the realm of where we're going before we get to that point of plea agreement. But a defendant does have the right to change his plea at any time in the proceeding, up until the point where the jury returns a verdict. So.
All right, so for trial preparation, we meet with all of our witnesses in preparation for trial. You always want to meet with the kind of double here, but meet with a witness present. So somebody else in your office present while you're meeting with the witness. And the main reason for that is in case anything is disclosed during that meeting with the witness that's new or different from what was previously disclosed in the discovery, then we cannot use that unless we go through the proper channels. And so, excuse me, if we're meeting with a witness and they say something they've never said before, there's some new evidence that we were unaware of, then we have to contact law enforcement, have law enforcement re-interview that witness, write a report regarding the new information, and then that discovery obligation that we have kicks in, and we have to get that report to the defense as soon as possible. And so you always want a witness present because we cannot be witnesses in our own cases. And so if new information comes to us, we do not want to be called to the stand to testify about it because then we can't prosecute the case. And so if that ever happens, you want another witness present that can talk about how the new information was disclosed. And so we can get law enforcement involved, get a new report over to the defense with that new information. When we meet with witnesses, especially victims, in these sorts of cases, I always take them through the courtroom and the setup. We take them into the courtroom, let them know this is where you'll be beforehand. When you walk in, this is where you'll walk to. You'll be sworn in here. We show them where the witness stand is. We'll tell them, you'll be sitting here. My team will be sitting at this table. The defense and the defendant will be at this other table. I always show them exactly where I'm going to put the podium when I question them, especially victims of sex crimes. Obviously, it's very difficult for them to talk about these things. It's one of the most one of the worst things that's ever happened to them. It's a very difficult thing to talk about. And so I always tell them where I'm going to put the podium, tell them, you just have a conversation with me while I'm questioning you. Defense counsel gets an opportunity to question you. Typically, they'll use the same podium when they do so. I'm always asked in these cases, do I have to look at the defendant? Almost every time that's a question that's asked. Let them know, no, you don't have to. You just look at me. When defense counsel's questioning, you just look at them. Most witnesses, we want them to testify to the jury, so we'll ask them a question. Want them to speak directly to the jury. But in my experience, when it comes to victims of these sorts of crimes, that's a very difficult thing for them to do. And so we try to keep them as comfortable as possible throughout the entire process. And so that's why I tell them just focus on whoever it is asking the questions, whether that's me or defense counsel. Prior to trial, oftentimes defense will ask for a defense interview, which allows either the defense counsel or their investigator to meet with the victim and question them about the case. They're protected by law, but we oftentimes will do them. And there's, as you see on there, some potential from the state's perspective anyway, and I think Eldina or Jordan may speak to this, but from the state's perspective, there's some possible positives and possible negatives that can be associated with a defense interview. Like I said before, we try not to re-traumatize the victim as much as possible. Having them asked about these questions, about these things, and questioned over and over can be traumatizing. And so we try to limit that. But one possible negative of a defense interview is if it's really, really difficult, sometimes they can get to the end of it and it makes them much less willing to testify. They're like, that was so hard just with you and defense counsel or the investigator. I don't think there's any way I could possibly do that in front of a jury. And so that's a possible negative of a defense interview. From the state's perspective, though, the possible positives is it's kind of a double-edged sword. It can go the other way. Sometimes after a defense interview, the victim will gain confidence from that and be like, that wasn't fun, but at least I know I can do it. I've gone through it once. I feel confident I can do that again if need be at trial. And so that can be helpful. From the prosecutor's angle, it can be helpful because lots of times, at least after that interview, you have an idea of where the defense is trying to go with the case, the kind of issues that they see, that they're going to try to point out throughout trial. And so that can help us kind of have a roadmap of how we want trial to go based on what we think the defense is going to do with the evidence that we have and with that witness. At the beginning of trial, or prior to trial, or during trial, we put together jury instructions, and those are essentially the laws that are the boundaries of the case. And so the judge will read those to the jury. Every jurisdiction is different. Sometimes they read them all at the beginning of the trial. Sometimes they read them all at the end. Sometimes they read a few at the beginning and the rest at the end. But it's essentially saying, here's all the elements of all the crimes alleged. This is what they've been alleged to have done. These are the elements that you have to find. And it's the case law that the jury has to consider when determining whether the defendant is guilty or not guilty. And those are the only laws that they can consider. And so when we get jury instructions together, we need to make sure we have every law that the jury can and should consider with regards to the alleged crimes, because those are the only laws that they're allowed to consider when they are rendering their verdict. And we meet with every witness. Typically, we have them come in and go over their testimony, make sure that what they remember is what we have in the discovery, because the last thing we want is a surprise, that they either don't remember something or remember something differently, or sometimes just aren't willing to testify. Obviously, we need to know that. So we meet with every single witness prior to trial to make sure we know what we need and what evidence we need to get in through each witness. Anything else on that, you guys?
I don't think so.
Okay, so once we get to trial, we'll go over who's involved. The trial is a public proceeding, so anyone can watch the trial. Witnesses usually are excluded until they testify so that their testimony is not affected by what they hear. And then once they testify, they can come into the courtroom and watch the rest of the trial once they've been released from their subpoena. And so that's a consideration for victims and their families should family members be called to testify. In felony cases, there are 12 jurors who are selected, and we'll get into that in just a moment and how that works. The clerk works for the clerk of court, and that person essentially manages the judge's calendar, takes minutes, and will issue a minute entry for each hearing, and then we'll do so as well for the trial. The judge will be present even if it's a jury trial. The judge is the one who runs the entire trial. The judges in Montana are elected. They can be appointed when another judge retires. The governor will appoint a judge to fill that judge's spot until the judge was up for re-election, and then that judge will run. If a judge is appointed by the governor, they need to either run for they need to either be confirmed by the legislature, and because our legislature occurs every other year, on the years in which the legislature does not meet, they actually have to run whether the judge they were replacing was up for re-election or not. The court reporter, you see those on TV, they type everything that's said. And so one of the things that I have to think about in court is we need to speak slowly. We have to make sure that I'm not speaking over someone else. Certainly attorneys object and then argue. And so the court reporter has to get everything down because they have to make a record. So we have to be really careful about speaking over one another. There's witnesses, which Brett just talked about, and the prosecution, the defense, and the defendant. That's kind of what we've been talking about all along.
This is our plug as a group, that jury duty is probably one of the most important things you can do in your community. people don't want to, they don't want to take the time off, they don't want to, like, for a million other reasons. But jury duty is one of the most important things you as a member of your community can do. There is a belief and that people should be adjudicated by a jury of their peers. Their peers cannot appear on a jury if their peers don't show up for jury duty. I think it's been in the news across Montana pretty consistently that, especially like in Yellowstone County, where folks are just not returning their jury summons and not appearing for court, and the sheriff's office are going out and serving summons and getting people to come in and do it. The justice system cannot function at the level it is required if people don't participate. So, and as a group of lawyers, like I'd love to be on a jury. I was just a year ago or two, was in the tribal jury pool, the county jury pool, and the federal jury pool, and I didn't get to sit on anything. But that's what we need. So we need, if you want really to have a jury of your peers, and you would want that if you were on the jury, if it was your case, you would want that. So this is our plug. It's a civic obligation. It is probably one of the most important civic obligations that we have as citizens, and people should return their jury questionnaires and participate in the process. And some of y'all are going to get bumped off anyway, right? Because of the work you do, but tell your friends, tell your family, make them participate.
Which of you brave souls were assigned to this slide?
I think it says
I have it was Jordan.
I apologize. All right. So jury selection, also known as voir dire. Voir dire is Latin for to speak the truth. We're going to talk about how that works. So the goal is to get 12 people who are able to be the most unbiased or the most fair. And in order to do that, the court will call in, if it's a sexual assault case and it's a felony, it's usually up to 100 people will come in. And then what the court will do is ask its own questions. They ask the jurors about their schedules, if it's going to be a 3-day trial. Do you have a plane ticket or something? Do you have a doctor's appointment that you can't miss on the 3rd day? Anyone who has scheduling issues, if they can be rescheduled pretty easily, the court may make them stay. But if it's something like a vacation or something like that, the court will release them. It depends on the jurisdiction how judges run their own voir dires. In federal court, the judges ask most of the questions, and then the attorneys have a very short amount of time to follow up. In state court, at least in Missoula, we usually get a lot of time to speak with the jurors. So what'll happen is there will be 24 usually who are called up, I guess, in front of the what is that called, Celine?
I would
in
say they're in
Missoula.
front of the bar, or like
In front of the bar, yeah. And so the
kind of
24,
well, right?
yeah, the 24 folks will be on the spot, and then the judge will ask the rest of the people who are there to listen, because they may be called to replace a juror who is excused. So the state goes first, and they ask questions of the jurors to see if they are maybe not the right people to sit on this case, right? So you can imagine a case of a DUI, and someone's family member was in a DUI accident, and it's a little bit too much for them to be present and hear the facts, and they may not be able to be fair. And so the state and the defense will try and find who those people are, and allow them to leave, because we both want the most fair jury we can get. In cases of sexual assault, oftentimes what the judge will do is say, if anyone, because of the content of this trial, is uncomfortable sitting on the jury, raise your hand, and then we'll go back into chambers, and the judge will allow that person to speak privately about their experience, or give the reason why it's uncomfortable for them and why they don't want to be there, so that they don't have to do that in front of 100 strangers. there are challenges for cause, and those are the challenges where the judge can just release someone, excuse someone from jury duty because they cannot sit on that case and be unbiased. In a case, like I said, with the DUI, say the state questioned a person and she said, you know, I'm sorry, I had a family member who was in a DUI wreck and I just can't be, I don't think I can be fair. The state will then say, Your Honor, I move to challenge this juror for cause, and the defense can either object or agree, and then the judge will remove the person. Sometimes the defense will make challenges for cause, and the state will think that they're inappropriate, or vice versa. And so there are times where the defense or the state may not object, and then you make arguments to the court and it gets litigated. So you can challenge as many people for cause as you want, but you have to have a reason, and the judge can just kick them off. And then what happens is at the end of the voir dire process, where the attorneys are asking questions to the prospective jurors, what we do is we execute our preemptory challenges. And I think this is really interesting, but I'm a nerd, so I'm sorry if y'all are bored by this. But what happens is we each get 6 bumps, essentially, preemptory challenges. And the state goes first, and the state picks one person that, for any reason other than you cannot exclude someone based on race, gender, or protected class, race, gender. You guys correct me if I'm missing anything
No, I think
there.
yeah.
Yeah,
That's right.
so but for any reason other than that, if the state gets a bad feeling about someone, if they don't like, the way they're dressed, the state can just say, I don't want this person on my jury. So they pick one person, and we each have 6. And then what happens is the defense picks one person. So it goes back and forth. So there can be some strategy involved in this. The state doesn't just pick their top 6 that they don't want, and then the defense doesn't pick, their top 6. It goes back and forth. So interestingly, I think, like, sometimes I'll sit there and be like, I wonder if the state's going to bump this person, if I should wait, if I should save that for my 6th bump or not. So it's a little bit like chess. At the end of that process, however, you end up with 12 people who, both parties have decided to keep, or both parties have decided that there were other people who were there who they wanted off the jury more than the people who were left. And so let's see, I'm trying to think what I'm missing. Identifying bias to find a perfect juror. I don't know that there's a perfect juror, but really each side is looking for different things. But at the end of the day, we are just looking for someone who can judge the facts and whether the facts, and apply the law to the facts, and do that without bias.
So once we go through the lengthy process of picking a jury, the judge will swear them in and trial starts. The first thing that will happen is the opening statement from the state will be given. Throughout trial, throughout this process, the state carries the burden. And so the state gets to go first and they get to go last. So here in opening statements, the state gets to present its theory of the case first. It's highlighting themes that the state may want the jury to focus in on as they hear testimony. It's talking about what testimony they may hear. And the important part is it's not argument. It's just kind of a framework for how the state, and then later the defense, wants the jury to think about their case as they're getting overloaded with all of this witness testimony and evidence. After the state goes, defense counsel can choose to go immediately after, or they can defer to their case in chief. And that's a decision that is individual to that trial attorney in that moment. And I'm sure there's thoughts and theories that go into it. So Jordan or Aldina, if you want to talk about that decision for you guys, you're welcome to.
I actually think I think it's best to go at the same time as the state, because we're both trying to tell you what's important, right? And what we want you to watch for. There are other attorneys I've seen who will wait until the end of the state's case and then make their opening because they think that it's more impactful for you to only focus on what they're doing. It's very tactical. And I think everybody, has their way of doing it. I've never done it where I delayed.
And that's the thing about trial work, is it has to be your presentation, right? Part of what we're trying to do, is build credibility with these juries. And so you have to be so authentic to yourself in presenting this evidence so that it, you want the jury to focus on the facts and not whether you're uncomfortable up there or whether you're saying something that maybe you wouldn't normally say, and juries can see that. So I guess that's one of the things I would point out is these kinds of decisions, the organization of a case, whether you decide to defer opening, it's really individual and based on a specific trial attorney's presentation standards and how they go about that. After opening statements, we will start with the state's case in chief. And again, the state goes first and it potentially goes last. And at this point, the state has to put on all of the evidence it believes is necessary to prove every element of every charge beyond a reasonable doubt. So that is testimony of a witness after they're sworn and asked questions. It's physical evidence or photographs or scientific evidence. All of that is governed by the Montana rules of evidence, as to things we can and can't do, as to the balancing of when evidence comes in and when it doesn't. Everything has to come in through witness testimony. And there are times where, you know, maybe the issue isn't whether the photographs were taken correctly. A photograph is what it is. And so there are times where the defense attorneys and the state attorneys will stipulate to maybe a foundational requirement that this evidence is what it is, and it was taken in the appropriate way. And that can help to speed up the process. So typically, I guess what I'm saying there is if there was photographs of a crime scene that were taken and I'm questioning Detective Gadarian, I would say, I would hand her a stack of photos and be like, Detective Gadarian, do you recognize these? She'd more than likely say yes, because we prepared and went over this sort of stuff before. And I would ask her generally, are those photos a true and accurate depiction of the crime scene as you observed it on the evening of X date? And she would say, yes, that's a foundational requirement. Those are some of the things that can be stipulated to kind of move trial along. The other thing that can be stipulated to, but it needs to be very, very clearly stipulated to on the record. We've harped on the fact that a witness has to testify personally at trial. There are situations where we can reach some stipulations on that, but it has to be that challenge to the confrontation clause has to be specifically waived by the defendant on the record. Otherwise it is a massive grounds for an appeal. But sometimes that can happen. So if you see that in a trial, that's probably what happened. I will just say the other thing we do, not only are we getting testimony of witnesses that were present, who may have had some sort of corroborating information, the science and that sort of thing. This is where we also bring in our potential expert testimony. So we might bring in an expert on victim behavior. We might bring in an expert on a forensic interview process. Our SARN nurses are potentially experts. We're talking about all sorts of things that maybe a regular person who hasn't been exposed to someone involved in the criminal justice system or have someone they've known be a victim, something of that. We're trying to explain some of these counterintuitive victim behaviors. We're trying to explain why the forensic interview process is a neutral process. We're trying to explain, you know, why you can rely on certain types of evidence, and that all has to come in our case in chief. And then with every state's witness that is brought in, defense has an opportunity to cross and ask their own questions. In the case in chief for both parties, you have to ask open, non-leading questions. On cross-examination, you get to essentially suggest the answer. So if I were crossing a defense expert, I would say, and I was asking about the weather, I'd get to say, it was raining that night, wasn't it? And that suggests that the answer was yes, it was raining. And so it's just one of those little distinctions. in terms of the rules that might be a little odd to people in terms of the phrasing and how things get asked.
Aldina, is this one yours?
It is. I'm just getting there. Okay. So, I guess I've never heard it phrased like that, Celine. So that made me laugh that we get to suggest the answer in cross-examination, which is true. So every witness that comes in front of the court and the jury has to be direct examined and cross-examined. But well, they don't have to be, but they can be. So cross-exam once the state is finished with their questions, then the defense has the opportunity to go up and ask questions related to the testimony that they've just given. If we try to ask them questions that aren't part of that testimony, we might get an objection that says outside the scope or something else. And it is very much that our questions are yes and no questions, directed to pull out any inconsistencies or, we generally have, like, we really prepare for these for trial in a sense of, okay, what is it we're looking to hear from this witness? And when you're doing cross-exam, like, you can write out every question you think you're ever going to need, and you might not use any of them. So it really is a quick, rapid fire development of questions of what you need out, of what that witness said during direct exam, and how you're going to address it on cross-exam. So cross-examination can be very quick. It could be a couple of questions. It could be a much longer process. There are times when we may not have any questions for a witness, depending on what value the witness brings to the case. If it's somebody who said, I was there, it was raining that day, this is all I saw, it might not help my case to ask that person any questions. Their testimony will stand alone. The one thing that's the public perception may be that there are these Perry Mason moments. There's going to be this one aha where you trip somebody up. That's not the purpose. That the purpose is to clarify information, gather information, because with all testimony, maybe they just didn't say it the way they said it before, and you want to make sure that that is the information that you're getting out to the jury. So it isn't intended to be this like shotgun style thing. It's funny when Jordan's like, in front of the jury, you have to talk a little slower. It's true, right? There is a presentation style where you want to make sure that you're heard and collected in this process. So cross-examination can be quick, it can be long. It really depends on the witness and the testimony and what it is that you need to get out of there. Anybody that the defense puts on the stand is also subject to cross-examination by the state. And whoever went first also gets to go last. So you can ask for rebuttal to clarify one or two other questions depending on it. But the scope gets narrowed by the original direct examination. The use of experts in these cases, we may hire an expert in DNA transfer. We might have an expert who talks about just about anything. It depends on the need of the case, but there will be experts. Like Celine had said earlier, we can challenge the credentials of an expert, whether or not they might be an expert in something, but they aren't an expert in this. And so we'll we'll have that fight outside of a jury before the jury ever gets there most of the time. And there may be then limitations to what that expert can talk about, or challenges if the court hasn't ruled in favor of our opposition. We may challenge that on the stand. There's always the issue of people saying, wow, so rude, interrupting, objecting. That's our job. That's absolutely what we have to do to keep the rules of the court and the rules of justice moving forward. Otherwise, it would just be this horrendous, messy, appealable free-for-all. So our job is to object on both sides. So we might object. There are lots of different kinds of objections, but you won't know the objections necessarily you need until you get in it, depending on who's testifying. So you might object to not laying enough foundation. You might object to leading questions when they should be the other format. There's lots of different objections. People are going to do it. It is not meant to be rude. It is not just a tactic. It is, if I don't object to something, I can't appeal it later. So it is a fundamental part of all of our jobs. And probably the other part of the defense perspective is the burden of all cases rests with the state, and you've heard that before, but it really does. So at the end of the state's case, we'll make motions that they didn't meet their burden to prove all of the elements. And the defense doesn't have to put on a case. If we think that everything that just went out there is not enough to convict the client, and then the judge isn't willing to give us our motion at the end of their case, we might send it to a jury. It's risky, but it's also what we have to do. So it is not on the client doesn't have to testify. The client doesn't have to put on any case. The client's case often is in our work on cross-examination. So there are lots of varieties of how this part of how trial plays out for different clients. But everything rests with the state, and it's important to remember, like, when people are in talking to juries during voir dire, they'll talk about the burden of proof and whether or not people can meet that. And just to reiterate, usually it's how certain are you? Are you certain enough that you would take somebody off life support? You need to be that certain. Because reasonable doubt is, beyond a reasonable doubt, is a standard that is not perfect. And so it's kind of about everybody's own sense of integrity and what that means.
All right, so after the state's case in chief and then the defense's case in chief, there's an opportunity for the state to have what are called rebuttal witnesses. Typically, those witnesses can only address evidence or issues that are brought up in the defense's case. And so if the defense has a witness that testifies to an element or issue that was not brought up during the state's case in chief initially, then it's the state's opportunity to present a witness to testify regarding that issue or piece of evidence that was brought up during the defense's case in chief. It doesn't happen all the time. I've done it before. There are certain instances where you need to, if something that we just didn't even talk about before is brought up during the defense's case in chief, you have to have a witness testify about that. And so we will do it, but it's not a super typical thing that happens in a trial. I already talked about jury instructions a little bit, but lots of courts read the entirety of the jury instructions prior to closing arguments. Some do them after closing arguments. Again, it just depends on the individual court. But again, that's the opportunity for the court to read the jury, the law that applies to the specific case and the facts. Then we have what are called closing arguments. The state goes first. We'll make our arguments as to why the elements of each offense alleged have been met based on the evidence that was put into the trial. After we're done with our closing, the defense has an opportunity to give their closing argument and argue why the state has not met its burden of proof. And then the state gets one more opportunity because it's our burden of proof. We get one more opportunity to rebut the defense's closing and talk to the jury just about what the defense said in their closing and why we do believe, despite the things said in the defense's closing, that we believe we've met that burden of proof beyond a reasonable doubt to convict the defendant of the alleged crimes. After our rebuttal closing is finished, the jury will go back to deliberate, and that's their opportunity to go over all of the evidence in light of the jury instructions and the law that's applicable and render their verdict of guilty or not guilty. It does require in the state of Montana that we have a unanimous verdict, and so all 12 members of the jury either have to determine that the defendant is guilty or defendant is not guilty. If they cannot do so, there is a possibility of a mistrial if they just cannot come to a unanimous verdict one way or the other. There is the possibility of a mistrial, in which case the trial would have to be retried. We'd have to do it all over again and hopefully get a jury that can make that guilty or not guilty determination and verdict. Once they have, if they are able to come to a unanimous verdict, they will report that to the court through the bailiff, that they've come to a decision. During that time, we're all sitting in our offices extremely nervously, just ready to hear what happened. At that point, our job is done and it's up to those 12 people. And so we await that verdict. Once it comes in, we all return to the courtroom. The verdict is read. Guilty or not guilty. If the defendant is found guilty at that time, then there's typically an argument as to whether or not the defendant should be in custody pending sentencing in the matter. In a sex crime, typically we will ask that the defendant be incarcerated, specifically because of the potential penalties as we discussed before. Many of these sorts of crimes have a mandatory minimum sentence, in which case the defendant is required to be incarcerated, especially if the victim is a child. And so we'll typically ask for incarceration pending sentencing in the matter. And the defense can argue as to why they do not believe the individual should be incarcerated if that's their position on the matter.
Before we get into this part, how about we take just a quick 5-minute bathroom break and then we'll come back and take public comment briefly, and ask for public comment since it was on the agenda scheduled at 11 o'clock in case someone's been counting on that time. And then we'll come back to the post-trial activities. How does that sound? Okay. All right, 5 minutes. So we'll just call it 11:05. We'll come back at 11:05. And we'll be ready for public comment at that time. Give it one more minute, so we start right at 11:05 or 30 seconds, whatever it is, till 11:05. Okay, it's 11:05, so we'll bring the Sexual Assault Response Network Committee back to order. And at this time, to honor, even though we're not quite done with our presentation this morning, we'll go ahead and honor the 11 o'clock call for public comment on any matter within the committee's jurisdiction. And so we have had about a dozen folks on this morning, listening all morning. So we thank you for your interest in the committee's work. And if you have any comment you'd like to make at this time on a matter within the committee's jurisdiction, go ahead and press the raise hand button at the bottom of your screen, and that will indicate to me that you're interested in making a comment. Just a reminder, this is for comments only. It's not a time where there's an opportunity to engage with the committee. If there's a question that you want to pose to the committee for consideration, you can do that, but it's not a time at which we generate that discussion unless it fits within the agenda today that's already been noticed to the public for participation. So again, if you're interested in making comment, please press the raise button hand. Raise hand button. Tongue twister for me this morning. I don't see any hands coming up. So last call. Right. We will proceed then with the remainder of the presentation this morning about the legal side of sexual assault response with our prosecutors and our criminal defense attorneys this morning. So take it away, team.
Okay, so we just finished talking about trial, and most of the cases in the criminal justice system do not go to trial. Most cases are resolved by plea negotiations and end up at sentencing that way. If the case does go to trial and someone is convicted, then we're here at the sentencing stage of the case. We put a lot of energy into the sentencing phase, and I'm going to start maybe at the bottom of this slide where it talks about agreed versus contested and the judge's role. So in Montana, the judge is the individual who imposes the sentence. In other states, the jury will select that. But here in Montana, the judge makes that decision. There's different types of plea agreements, and Celine had touched on this and referred to a 1C plea agreement. And that's where the parties will make a recommendation to the court, and the court's not bound by that recommendation in a plea agreement. The parties could make a recommendation that they agree upon, or it could be contested. So the state could say, I'm going to cap my recommendation at 50 years, and the defense could say, well, we're going to argue for 25. And that's when a lot of energy goes into those sentencing hearings. An agreed upon recommendation is just that. It's that the parties agree that they're both going to recommend the same thing to the judge, but ultimately it's the judge who decides. It's not the attorneys, and the judge has to be the one that agrees, yes, this is an appropriate sentence. When there's an agreed upon recommendation, oh,
sorry,
that's okay.
Operator malfunction here.
That's right. You'd think I could talk without staring at the slide. So when there's an agreed upon recommendation, I lost my train of thought there. There's not argument really. Sometimes we come into court and we tell the judge things that we think the judge should know so that the judge will agree with us, but we're not arguing with the other side about what is the appropriate sentence, and so contested hearings are where most of the work goes. So I'm going to skip back to the pre-sentence investigation though. Once someone has pled guilty or has been found guilty by a jury or a judge, there is a pre-sentence investigation. That is conducted by a probation officer. And the reason for that is if there wasn't a trial, the judge knows nothing about the case, right? The only thing that the judge has seen at that point is maybe the plea agreement, the change of plea wherein the defendant admits guilt and speaks a little bit about what happened, but not a whole lot. Usually it's the bare minimum, and the charging document. The judge may know about the defendant's background through bail arguments, but the judge really doesn't know much about the case at that point. And so if you can put yourself in the place of the judge and think, okay, well, I'm going to be making a decision about whether someone is going to prison and for how long, you'd want to know who that person is and what they did, what their history is, what if they have any criminal history, and also the facts of the case. So the probation officer is tasked with reviewing the charging documents, and the probation officer can review all of the discovery or the evidence in the case, interviewing the defendant, our client, and putting together a report to the court. That report includes the client's criminal history, any statement that the client makes about the case. It often includes victim impact statements. The probation officer will reach out to victims through the CVA or through the county attorney's office to get those statements if they want to provide a written statement to the court. It's not the only way that a victim can provide a written statement to the court, but that is one of the options. It includes, I think I said our client's criminal history, financial background, if there's a restitution in the case and the judge has to make a determination about, and fines, if the judge has to make a determination about our client's ability to pay, it gives the court an idea of our client's earning ability and how much money they may have. It goes through chemical dependency, history with drug and alcohol use, mental health. And then also recently they've been doing a risk assessment, and they always do risk assessments. This one's new, but they ask questions about what neighborhood, like what's the neighborhood like where you live? Do you have friends who are involved in the criminal justice system? And all of those things are set to determine a risk level. And then that is included in the pre-sentence investigation. And so hopefully by reading that, the court then is able to have a better view of the case. The one thing that I left out is that the probation officer will summarize the police reports. Sometimes they will just cut and paste the affidavit. I guess it was a while back when they were getting the police reports. I don't know that they actually do that anymore, but they used to call the office and ask for the police reports all the time. Then oftentimes attached to the pre-sentence investigation is a psychosexual evaluation. In misdemeanor cases, they're not required, but in felony cases, the judge will order a psychosexual evaluation for sex crimes. That is when the client will meet with someone who is qualified to do those types of evaluations. It's an interview, and then there's all sorts of testing. The psychosexual evaluator is usually like a PsyD level doc or psychiatrist. I haven't seen one who is a social worker or that level, but I could be wrong about that. It takes a couple hours, and there is a battery of tests that they do, as well as the interview, like I said, and then they write up a report. And you'll also find within the psychosexual report a whole history of the client as well. The psychosexual evaluator will write recommendations as far as tier designation. So in Montana, we have levels 1, 2, and 3, level 1 being the lowest risk to reoffend. And, you talk to different people about the ability to make risk assessments and the science behind that. It is very difficult. And so it's hard, I think, for psychosexual evaluators to really put people in those, especially if you're looking at 2 and 3. I mean, some people are really clearly a 3 and some people are really clearly a 1. So don't ask me about exactly how they come to that number, but they make that recommendation to the court. The statute requires the court to designate a tier level, and that is because the tier level, it gives information to the public, it gives information to the Department of Corrections, and the tier level ultimately determines the length for which the client has to register if they're convicted of a sex offense. So there's all different types of sentences, from probation or maybe just or unsupervised probation to prison, right? There's what's called a suspended sentence, and that is just probation. And then there's a Department of Corrections sentence, which is a sentence to the Department of Corrections. It doesn't mean that you're going to prison. It means that the Department of Corrections will decide where you go. So they will assess you, and they will determine whether you're appropriate for probation, pre-release, treatment, or prison, and or maybe heightened probation. So there's a whole spectrum of sentences that the department, or placements that the Department of Corrections can choose. So for someone who gets a Department of Corrections sentence, it doesn't necessarily mean that they're put into prison. And then there's a prison sentence, and the judge ultimately is going to make that determination. And y'all hop in if you think I'm missing anything here. Some cases require mandatory minimums. We see that a lot in sex cases. I don't know the lowest one in a sex case, but the highest mandatory minimum in a sex case that I'm aware of is 25 years. The lowest is either 2 or 4, I can't recall. And the statute requires the court to impose that sentence and not suspend it, usually in sex cases. There are exceptions to the mandatory minimum, and I should actually just pull that up to make sure that I don't forget any. But I can speak on that while I'm looking at it. One of the exceptions to the mandatory minimum is that the offense was committed while someone was under like extreme emotional distress, and that requires an evaluator to make that determination. Other ways that and the way we talk about it as attorneys is get around the mandatory minimum. I think both sides say it that way. 222, let me just pull it up. If the offender was less than 18 at the time, you can make an argument that the mandatory minimum shouldn't apply. What I was just talking about depends on the mental capacity, if they were so significantly impaired. Let's see. Was acting under substantial duress. That one is not one that we see very much. Was an accomplice, meaning that they didn't commit the offense themselves, but they participated in it, and that their participation was relatively minor. And then some of the offenses say that 4618 222 doesn't apply. So that's ultimately going to be up to the judge. Let's see. Parole restrictions. So in Montana, if I'm sentenced to 10 years in prison, I have to serve a quarter of that time before I am eligible for parole. And the parole board, when I serve after I serve 2.5 years, they review my case. The victim has the opportunity to testify at any parole hearing and submit their opinion about parole. And so the court can, however, impose restrictions on parole. And so the court could say, Jordan, you were going to be sentenced to 10 years with, and that means that you'd have parole in 2.5 years. But because of the severity of this offense, I'm going to put a parole restriction of 5 years, or a parole restriction of that you have to serve the whole time, no parole. Oftentimes we see in sex cases parole restrictions of you cannot parole until you're done with sex offender treatment. And that means that you have to do sex offender treatment in custody, in prison. There was just a recent case where the defendant was, and it wasn't my case, but he was in the community and he just could not get his sex offender treatment done, over and over again, going back to court and the state saying, look, this is a condition of your sentence. And the court sentenced him to prison with the parole restriction being you have to stay there until sex offender treatment's done. So those are often ones that we see in sex cases. The other one that I've seen is a parole restriction, say, until the child reaches 18, right? So the defendant doesn't get out until the victim is of a certain age. I talked a little bit about about the impact statement. Victims can write impact statements, submit them to the court. They can submit them directly to the court. They can submit them through the prosecutor or through the probation officer. They have an absolute, well, I shouldn't say absolute, they have a statutory right to participate in the sentencing hearing. I feel that that is absolute. They can come and tell the court how they've been impacted. Additionally, if they're not comfortable speaking, at least in Missoula, and I imagine other offices do it the same way, there is someone, a crime victim advocate, or even the prosecutor could read a statement for them. Ultimately, though, the judge is the one that's going to make that decision about what the sentence is, and the sentencing hearing is just an opportunity for the judge to get as much information as possible, because like I said, sometimes they have very, very little information about the victim, about what happened, about the defendant, and the whole case, because it hasn't been presented to them, and they have a very large caseload.
Before we move forward, Christina has her hand up. Christina, did you have a question?
I did. What was my question? Oh, it was, can we go back to where the DOC gets to make a sentencing outcome? What assessments, how does that work?
That's a really good question. Yeah, that's a really good question. It's almost like we're not exactly sure what happens, right? So there's different screening tools that they use. And so they will screen people to determine if they're appropriate for pre-release, if they think that that is an appropriate sentence or placement for that person. When you're sentenced to the Department of Corrections, unless you've been screened prior to sentencing, you're placed in custody, and then you're sent to, and maybe Brett or Celine know exactly, or Eldina know exactly where this process, so I'll stop and see if you do.
Well, I think, are you talking, it's not mask anymore, but what we
No.
used to know is mask.
Yeah, it used to be
Or
mask
START.
here in Missoula. Or
START was for women, I believe.
okay, or START.
But essentially, it's a DOC facility whose sole purpose is screening for then appropriate placements within another DOC facility.
Yeah, it's
and
mask.
they do. Sorry. Yeah, and mask it used to be in Missoula, and it's no longer here, but they do screening for chemical dependency. So if it's a drug case and someone has a methamphetamine addiction or an opiate addiction, they'll send you to their treatment facilities that are lockdown facilities. If it's a case that is, the facts are just egregious, they may just send you straight to prison. Oftentimes the judge will send someone to the Department of Corrections when prison isn't what the judge thinks is appropriate. And so usually within the Department of Corrections, though, it gives someone an opportunity to say do pre-release or even ISP, which is intensive supervision. And if they violate, they don't get to come back before the court. They could just be sent to prison. So there's other opportunities, and I don't know much about how they screen for that. I know that when they do the pre-sentence investigation, there are opportunities to be screened for programs. If you think that your client is going to go into the Department of Corrections, sometimes we'll ask, can you screen her or him for this particular pre-release?
Good to know. Thank you.
Eldina, did you have something else you were going to add?
I might have, but I also might have forgotten it.
Sorry, Eldina.
No worries, Jordan.
We'll start the screen share again, and if it comes back, you can.
I think that's all I had for sentencing.
Can I chime in on just a couple things, Jordan?
Oh, yeah.
So just for everybody's information, the pre-sentence investigation report and the psychosexual evaluation, those are not public documents, those are confidential. They follow the offender throughout his time in Department of Corrections or Montana State Prison or whatever program he's in. But those are generally not available to the public. Was the first one. And then the other thing I would just point out is Montana's sentencing considerations are codified, oh my gosh, 46-18-101, I think. And so there are a number of aspects when a judge formulates a sentence that they're supposed to consider. Some of it is punishment, some of it is rehabilitation, and others like reparation and restitution to the victim. So it's looking at a lot of different facets of what's required in this case, and a judge is supposed to consider all of them.
Okay, so kind of the last little bit about this is post-conviction. Once a client is convicted and sentenced, we as defense attorneys have a duty to review the judgment to make sure that the written judgment says what the judge orally said on the record in the courtroom that day. Sometimes maybe the dates are wrong or there's some confusion. So we have to wait and make sure that the judgment is correct. If not, we will have to file a document that requests that the court match the pronouncement and the written judgment, because the written judgment also follows the client, right? That will go to the Department of Corrections and follow the client for the duration of their sentence. And within the judgment, along just the pre-sentence investigation, are conditions, should that client ever be released from on parole or on probation, there are conditions that they have to follow during probation. So those are all included in the judgment as well. Once the judgment is solid, the client has some deadlines that they have to meet. One of those is sentence review. Sentence review is a 3-panel, we'll call it a committee, that is made up of district court judges, and a client can go take their sentence to these judges and ask that it be reduced. The risk of sentence review is that the sentence can be increased, or it can be decreased, or it can be left alone. And all clients are made aware of this when they go into sentence review. More often than not, the panel leaves the judgment as it is. Sometimes they can find that the judge abused their discretion and lower it. I don't think I've seen in the last several years where it got increased. But there is a review that a client can go to and have their case looked at one more time. What can be presented in sentence review is very, very limited. So it isn't an opportunity to retry the entire case. It is just a very narrowly tailored process. Not as part of sentence review, but kind of on a separate track, but moving at the same time, a client has an opportunity to appeal, whether the appeal is whatever the issue may be, whether it can be ineffective assistance of counsel if you went to trial. It can be there can be an appeal on a motion that was decided against them pre-trial. People have the right to an appeal. Appeals can take a long time in the process, but they do happen. There are times that things get overturned. There are decisions that have to be made. One of the things that I think it's fair to say about judges is that we ask every judge to make split-second decisions, right? Somebody's testifying, one person jumps up and objects, makes their argument for an objection. The other side gets to make their answer as to why it should not be granted. And we ask judges to make split-second decisions. You don't always get it right. And as attorneys, we don't always get it right. And so the appeal process is to make folks whole in a way, in any way that they can. So there are lots of issues that can be brought up on appeal, and everybody is entitled to that. Like Celine had mentioned earlier about constitutional issues like confrontation. if somebody's not in the room or there's hearsay coming in or something like that, we have the opportunity and we actually have a duty to appeal those things. Clients can choose not to appeal. If they just want to, like, they got what they got and they're willing to take it and go, they don't have to appeal, but they can. And it is their right to do so. A parole hearing. The Board of Pardons and Parole is I believe it's 6 people who are appointed and hired by the Department of Corrections in the state of Montana. The parole board is a different format in the last, let's say, 6 years. And like Jordan had mentioned earlier, if you get an active sentence, which means you are committed to either the Department of Corrections or Montana State Prison, when you have served a quarter of that time, so we'll use a 10-year sentence, after 2.5 years, you are parole eligible. In cases like these, rarely does a person get paroled out at their first parole hearing. The parole board considers whether or not they've gone through treatment and what levels of treatment. So in the prison, there are sexual offender programming. There are two different sexual offender programming 1 and sexual offender programming 2. Some people are ordered that they have to complete both of those. The time they wouldn't get to be able to do it within the first 2.5 years. So parole hearings are actually, they're published, not published, but there's a disposition sheet on the Board of Pardons and Paroles where you can see who was up for parole and why or why not they were given parole and what conditions they were given if they were allowed parole out. One of the things that is noted about parole is that means that they are being released from either the prison or the Department of Corrections back into the community, but with very heavy restrictions. And so if they do something wrong, they can have an administrative hearing, but they don't get an attorney again. So that's something that happens with parolees only. There's also what is called probation, right? Probation and parole are different things. So if somebody does their, let's say, 4-year mandatory minimum, and that was the sentence that they got, and they're back out now to finish the 6 years that they got on probation, they have a probation officer, they're in the community, they have restrictions, they have all of those conditions that were in their original judgment. If they do something wrong, the Department of Probation and Parole, they actually have more rights in the process. So they will have a hearing, they're appointed an attorney. When you want to revoke somebody's probation, there is more of a process, but people can be revoked and resentenced. So those are the and then post-conviction relief really is sentence review, appeal, and that's what am I missing? Jordan, what am I missing? I think that's it. Sentence review, appeal.
And then there's post-conviction proceedings, which is a civil process.
Thank you, Celine. I'm like, what am I?
Yeah. It is a totally different standard, but it can again look at ineffective assistance of counsel. What else am I thinking? Newly discovered evidence. What am I missing? It's a more limited range of things that can be considered. There's very strict time limits to that as well. But it's just one more process in which the entire process gets another review in a different way, I guess is how I would say it. And it's all within the realm of making sure the decision was right. Go ahead, Brett, sorry.
That you're fine. That has to be filed within 1 year of conviction. So that's your time limit for for that type of post-conviction relief.
And I mean, at least in my experience, it's not super common. But you know, there are people who pursue that. So I'm not well versed in that part of in post-conviction relief. So if there's somebody who has more. And that is the end of our process. I did just kind of hint like there are chances that we may see the client again. That would be in a petition to revoke somebody's probation. And those all have different, that has a whole different process. It's another legal proceeding. But, and I also just really want to emphasize that everything that we're talking about is for adults. In Montana, if somebody is charged under the Youth Court Act, they can be tried as an adult for sexual intercourse without consent. There's a whole different process to that about how we would handle those cases, but this is the very broad overview for an adult client defendant, regardless of the status, meaning age or relationship of the alleged victim.
Well, thank you, everyone. Any questions? Whitney has a question.
Yeah, I was wondering if you guys could talk a little bit about the cost of trial and the cost of that, and then also curious on who pays for, like, if you have an expert witness come in on either the state or the defense side, who that is covered by, and yeah, I think that's my question.
Brett, do you want to cover the state side since the Attorney General's office has a different kind of?
Yep, sure. So I'll start with the experts. So for experts, we have to cover the cost of those experts on the county level. There are mechanisms in place for us to get grant funds after the fact, to get reimbursement for some of those sorts of costs. But generally it falls on the individual county to do so. We have to incur those costs at least initially, if not forever. It is our responsibility as well to secure witnesses, and so we have to pay for flights or those sorts of things to make sure that we can get people to trial as well. The cost of the jury can be incurred by the defendant, and I don't actually off the top of my head know what those costs ultimately end up being. It really depends on the length of the trial. I do know that the amount paid to jurors per day, I don't think has been increased in, I don't even know how long. It's minuscule, and maybe something that needs to be reevaluated by the legislature. Maybe that would help us get people to trial a little bit. But yeah, that's from the state's perspective. Does that answer your question?
Yeah.
Was there another part of it that I missed?
No, you talked about the expert in the state, and then, Alvina, for if you guys hire an expert, does that come out of the Office of Public Defender, budget? Or does
It
that fall
does.
back on your client?
No, so because all of our clients, private attorneys and private pay stuff are different. If you're a public defender client, under State v. Mitchell, we are required to put forth the best defense we can, and that includes expert testimony. And so if we need an expert, we gotta find an expert. We're gonna pay an expert. We pay reconstructionists. That all comes out of the public defender budget, right, for contract services. If I want to get my client a sexual psychological eval prior to be used in plea negotiations or something like that, that also comes out of the public defender budget. The only real thing that can be charged to the client tends to be the cost of the jury if they go to trial, which sometimes is that like thousands of dollars. So we're already saying you're indigent. And so when we go to sentencing, we're going to object to those costs. The county incurred them. They're like, a client has to pay to exercise their ability to go to trial. So we object. Sometimes judges give that to us, sometimes they don't, but we pay for the experts, we pay for the evals, unless, excuse me, if I enter into a plea agreement with Brett and my client accepts it and we plead it out and we don't have any evals and the court orders a sexual psychological eval, the court has to pay for that. The court can pick the evaluator, but the court pays for it out of the court administrator's budget, I believe. So everybody pays for their own experts. Jury costs and trial costs are usually imposed on the client, to which we will object because they're indigent. And also there's a lot of costs in the judgment that come out for the Department of Corrections. There's like technology fees and the cost of prosecution and the public defender fee. We're going to object to all of this because the client is indigent, but they can be ordered. So, and there might be a fine, right? Some of these come with, well, I think all of them come with a fine. So that's where the money is being spent, is experts, evals, and we don't, the public defender office doesn't pay for like the cost of a jury.
Okay, thank you.
And Emily's hand is up.
Are you guys able to speak to a little bit of like fact versus expert witness? I feel like a lot of nurses are hesitant to join the world of forensic nursing because they don't want to testify specifically as an expert. So like what meets that threshold for you guys? And then like if that nurse was called to testify, if they were the practitioner doing the exam, would they be more of a fact witness or could they be qualified as an expert witness?
Yeah, I'm trying to get this straight in my head. So, witnesses, whether they're lay witnesses, which are a fact witness, or an expert witness, governed by the Montana Rules of Evidence, to be an expert is actually a really low standard, at least in my perspective. You know, it's any sort of training or experience that gives you more knowledge than a normal person would have. And so I would say in general, a nurse is considered an expert under that. Sometimes they can be kind of hybrid, lay and expert witnesses. We generally don't call people quote unquote experts anymore. We have a jury instruction that says a person may be considered an expert, but I generally wouldn't say qualify Whitney as like, Your Honor, the state tenders Whitney as an expert in forensic nursing. Like I wouldn't say that anymore. I would say most often they would be considered an expert because they have to have training and experience to be able to explain the injury or lack thereof and the procedures and that sort of thing that they're following. But it's just what it boils down to is testifying to your experience is all the major differences. And y'all can correct me if you have a different perspective.
No, I think that's accurate. I mean, it's anybody with scientific, technical, or other specialized knowledge that can assist the trier of fact in understanding the evidence. And obviously anybody in your, the position of the nurse has some scientific and technical experience and knowledge that just the layperson wouldn't know. And so anytime they give an opinion, even if that opinion is about injury, possible mechanism of injury, anything like that, they are going to be technically considered an expert. But like Celine says, we don't qualify individuals as experts on the record. Kind of allow that to be a determination to be made by the jury. We would lay foundation, obviously, as to their qualifications to testify about, the things we're asking them about. But the questioning for them, whether or not you're considering them an expert or not, really wouldn't change. I mean, they're going to be testifying to the facts, and then we may have to ask them an opinion question. And that's really the only time you ever get into the realm of an expert is if they're making an opinion based on their scientific, technical, or specialized knowledge. So I think they technically would constitute an expert, but I don't know that I would consider them that in the way that you're thinking.
Other questions? Well, I'd like to go around the table and do what we've done in our other meetings, doing a bit of a round robin and reflection on today's presentation and thoughts you've been having around the issues that the committee is hearing and learning about. Let's see, I think I'm going to start at the bottom of my screen here with Mark.
Boy, yeah, I learned a lot today. Great presentation. I want to thank all the presenters. Just really helped me kind of understand what you all do. And I really don't have any questions right now.
Thanks, Mark. Jamie?
I really enjoyed the presentation. For us here at the Crime Lab, we play such kind of a small role, a small puzzle piece to the bigger picture. And so it's interesting to see how the legal side of building a case or what components are needed to bring a case to trial, and how to proceed forward. So I really enjoyed it.
Thanks, Jamie. And just for everyone's awareness, Brett Taylor was here listening this morning. He just had to step off. So he's not here, but he has been here this morning listening to the presentation. Detective Gadarian.
Great presentation by all of you guys. I thought it was really interesting. One thing that stood out to me is just how long these trials are. I see it firsthand too. I go through it all, and trying to keep a victim on board with prosecuting throughout that time can be very challenging. I understand that we don't want to, violate anyone's rights by going slower, not doing everything correctly, but that's just one thing that stands out to me is the frustration of how long these can take.
Brenda?
Thanks, Hope. Yeah, great presentation. I think the thing I really liked was just hearing from the different perspectives, and seeing it from all sides. I've worked in prosecution for years, and so I just really enjoyed listening to each of your different perspectives on the different issues that you face, whether you're the defense attorney or the prosecutor. So, and I agree with Kara, Detective Gadarian. It is hard in these cases because they take so long to kind of help keep victims and their families engaged in the process. So you have a big challenge.
Thanks, Brenda. Christina?
Yeah, that was jam-packed, you guys. Very, very well done. Very well done. I have a lot of thoughts on it, but that the one that I wrote down for me to mull over was, I've always thought that there must be some way that we can be more helpful with Rule 3.8, because I think that one really gets in our way a lot, that the burden of proof is, I just always think that there must be more proof that's out there that, gets missed in investigatory process that other disciplines in the case could help with. But, so that's when I walk out. Don't live in horror. There's nothing I'm going to do about it. I'm just going to mull it over.
I have noted that you are mulling it, and maybe someday we'll pull that thing back out of the cider and mull it some. Emily.
Thank you guys for the presentation. It's always interesting to hear like all the different perspectives, and I feel like we don't often get to hear the perspective of a private attorney or a defense attorney to hear what your job entails and like what your like process is and sort of like what your burden is as you go through the process with your client is really kind of refreshing to hear like what is afforded to that individual as well as like what the prosecutors have to go through in order to prove the case to even get it to the point of court. So thank you guys for the education and thank you for what you do.
Whitney, I'm going to turn to you.
Yeah. Thank you guys for the presentation. I really enjoyed it. I learned a lot. And also just a refresher on some things as well. I think it's helpful to understand why we have the barriers. I don't know if that's the right way to say it, but there are barriers in our system. It's helpful to understand. Does it make it sit well better? I don't know if that makes any sense either. It just seems like there's so many challenges towards really, it just seems like it's not a very victim-centered process, and understanding that there are reasons why, and you think about how long these cases take and why that might defer or deter somebody from reporting, and how many cases are already unreported, and it's just it's a really hard thing to understand. And so thank you for sharing some information and helping me understand a little bit better, and thank you.
I'm gonna turn to the presenters and ask them if they have any reflections. And Celine, since you're in the room next to Whitney, I'll go with you first.
Yeah, I guess the thing that was challenging, at least for me, is what we talked about today really is kind of the tip of the iceberg of everything we do on both sides of this. Like we, in our present, or our groups trying to get this presentation put together, we really had to limit ourselves so as not to overwhelm you, because there are so many things that can happen any minute of any day that can change any case that we're dealing with. I guess that's just the thing that I wanted to point out. Like, this is not the end all be all of our world. This is not the end all be all of like sex assault prosecutions and defense work. There's so much that goes into it, above and beyond what we've talked about today. So it's definitely a rewarding job. It's a frustrating job. And it's just one of those things where you want to get it right, because the consequences either way are devastating.
Brett?
Yeah, Celine kind of took exactly what I was thinking. I think if we would have pulled you could pull any one of these slides on here and given us 4 hours, and we could probably fill it with information, because there's so much more that goes into all of this. But hopefully we were able to distill it into a form, and the information that's pertinent to what we're trying to do here. That was really kind of our goal, and hopefully we accomplished that. But yeah, I just appreciate the opportunity. I agree with Whitney. It is a frustrating process sometimes. The amount of time it takes is frustrating. But I do firmly believe in our justice system. I think it's the best there is in the world. It's certainly not perfect. But I think its goal is to get it right at the end of the day, and whatever that means, whether that's a conviction, acquittal, or somewhere in between. That's our goal. I know as prosecutors is to get it right, and if that means we don't charge a case, that means we don't charge a case. If that means we go to trial, even though we don't have the best case, but we hope we can prove it with a good jury, then that's what that means. So, yeah, I just appreciate the opportunity.
Thanks, Brett. Jordan? Letting the prosecutors have, or pardon me, the criminal defense members have the last word, because they don't normally get the last word in the
Love
trial.
it.
Thank you. Thank you, Hope. I think that one of the things, whenever anyone is involved in the criminal justice system, the process can really affect people's dignity. And as a defense attorney, regardless of what my client is charged with or, convicted of, one of the most important things to me is treating defendants, my clients, like they're human and they have dignity. And I think that even when facing mandatory minimums of 25 years, right, that's one of the things that we have to remember. And one of the things when I was a prosecutor that I think it was hard for me to remember a lot of the time, given the types of offenses that people had committed and were facing. And so as a survivor entering the system too, the system takes away your dignity as well. And so it's just, as practitioners in the system, it's something that I try to remember and just treat everyone as human. And when people come to me, it's usually on their worst day, one of their worst days, and they have a history and a reason for being here and exploring that, and they have families, and that's one of the best parts of being a criminal defense attorney. But I think that goes for both sides. It's just a really nasty system, and it's awful for everyone involved. And so for us to be able to hold people's hand through that process is really an honor.
Eldina?
Yeah, I mean, I would just double down on what Jordan was saying, and along with respecting the dignity of our clients, it is also to confirm the integrity of the system, right? We want to have a system that has integrity, and that's why it takes so long. I've stood with a client when he knew he was going to prison for the rest of his life. Took responsibility for what he had done. He still is a person who's now going to be warehoused somewhere. And I couldn't do this work if I didn't remember that everybody standing next to me deserved dignity, integrity, and to not have to stand by themselves. So the work we do on both sides of this table are so incredibly important. And all of the parts and the pieces that you all bring to it are equally important, because at the end of this process, somebody's either going to prison or some kind of impact, or somebody's not, and that has its own impacts. And we cannot create a stronger community without all sides of this process.
Well, thanks to everyone. And I just want to say, from sort of an exterior observer, as these four put together today's presentation, in spite of being on opposing sides, they really worked together as a team and took time to listen to each other and make space for each other's perspectives. And I appreciated that about how you structured the process and putting your work together. So thank you for that. Want to take a little bit of time here to look ahead into 2025. I appreciate everyone who, before I do that, any last comments or questions? I apologize.
Is that all of the presentations from our team, or do we have anybody else left?
So 2025, we do have a couple of pieces left here, and that's what we'll focus on in the start of 2025.
Oh.
Yeah, and how we start structuring 2025. So thank you for your responses on dates that you are available in February and March and June. February and March are a little more clear maybe than June. February 21st appears to be the ideal date. And it's also made ideal by that is the date that Jamie Bray Tanner is available. And we'd like to have her and Lacey Van Grinsven come and speak about the crime lab's role in the process. After a kit's collected, what happens from there. And Jamie has said she'd like to do that as a dual presentation with Lacey. And so we'd be looking at February 21st for that. Also on the 21st, we're wanting to catch up with Sue Parker at some point about her work at the Redbird Women's Center, because she wasn't able to be with us last meeting when we had the larger discussion of the role of victim advocates. I need to double check with Sue whether the 21st of February will work with her. If it doesn't, we'll look toward March and bring her in at that time. The other piece that we'd like to really start the conversation on is to go back to the Forensic Rape Examination Payment Program, revisit the basics of the program, but particularly the payment structure. Right now, we have that $600 cap for what the state pays for kits that are collected, but then are not reported to law enforcement and instead are held. We know that that dollar amount has been in place for almost 20 years, and it's not meeting what the expenses of the healthcare facilities are. And that is a major talking point in conversations around the future of availability of forensic care in Montana. And so we'd like to kick off that conversation early in 2025. It will be an iterative conversation and leading toward a discussion of what would be a different amount or a different structure for payments in Montana. What would be the budget that would be required to achieve that, with an eye toward starting the conversation early next year and working toward conversations about all of those pieces and parts that would have to come together. There's a lot of considerations to be made, impacts to law enforcement, because they're paying currently for budgets that are, or pardon me, for exams that are conducted in cases that are reported. And so there's many layers. So in addition, in February, I'd like to bring back that prep conversation, lay the foundational pieces briefly, and then look at how other states are structuring their similar programs for those exam payments. We had a great report come out of the federal GAO office on the 50 state comparison, and I've taken that and broken it down further. And we'll get that to you in advance of the meeting so that you have a couple of weeks at least to look through that, and then we'll present on it and discuss it in the meeting. We will get to a point, I'm going to be starting to do research with the local law enforcement jurisdictions and the medical facilities about how they're handling that payment relationship when cases are reported, so that I can bring you information maybe at the March meeting about the law enforcement piece and how localities are paying for those exams and the differences or not between localities. So that's how we're going to start that conversation and keep stepping it out through 2025, probably into 2026. The other thing I'd like to do at the February meeting is just give you sort of a 2024 year in review, a brief rundown of the data from 2024 on kit collection and number of exams in Montana. I did some number crunching last week, and we're looking at a roughly 6.5% increase in exams done in 2024 over 2023 across Montana. And I think some of that we can attribute to the training that DOJ helped host last spring, and also programs coming back online or reawakening. And so looking at some of those things with you. The other piece in March that we'd like to come back to with committee members' work is that telehealth piece. How does telehealth work? What are the considerations if that's to be something that might help advance forensic care availability in Montana? What do we need to be thinking about? And so, Mark, does that feel right to you to come back at that March meeting? We'd look to talk and bring into that conversation probably Ben Ulick because of his background with telehealth with the VA system, and then also Brett Taylor talking about the security considerations, but really kind of focusing on that, starting that telehealth conversation in March and seeing where that leads us through 2025 with other pieces that we might need to consider and come back to for the committee's discussions.
Yeah, I think that would be a good timeline.
Okay. And then the June meeting I've roughed out, and so February 21st, going back to dates, is the February date that seems pretty obvious. The March date, probably looking at the 2 Fridays, I need to get a little clarity from the folks who did not respond on that one. But it seems like one of the 2 Fridays in March, either March 21st or 28th, are the most likely dates for March. And then April and May are just kind of bonkers around here and for me personally. And so looking then at June for the next meeting for an in-person meeting, having our opportunity, our once a year in-person gathering to reconnect and discuss things, and not knowing what might iteratively be going on with the various conversations we're going to percolate between February and March, but bringing whatever those next iterations are to that June discussion, but also then those consent conversations that you've expressed interest in having at your 2 previous meetings around, for instance, adolescent patients and the differences in jurisdictions between when they can consent to an exam on their own, or the mandatory reporting requirements. Do they or don't they apply depending on the age of the teenager, what jurisdictions are doing differently, and having a conversation around that Christina had particularly, put that up as a thread we might pull on here. And then also looking at those public education pieces that you all were interested in. And might, start having those conversations at the June meeting about what we're seeing based on conversations on other topics. Where does that lead us as we think about public education and what the committee might do under that portion of its banner and charge that was given by the legislature? Any comments, questions, thoughts to share?
For the February meeting, is that gonna be all day or half day?
No, it would be, I was anticipating the morning of the 21st. Jamie, how long of a presentation do you think you and Lacey would do that morning?
I think probably a couple hours, maybe 1 to 2.
Okay.
We can give you kind of a better idea as she and I have been chatting a little bit about what we want to cover. So I would schedule 1 to 2. I mean, I could talk for a long time, but we'll
And
condense
you're not
it.
even an attorney, Jamie. Come on.
Oh, we've got a lot going on. So, but yeah, about probably 2 hours would be safe estimate.
Okay. So we're probably looking at a full morning, say 8 to noon on that 21st. Brenda? I'm sorry, Christina had her hand up. I apologize. Somebody had their hand up.
I did.
Oh,
I
okay.
just unraised my hand instead of unmuting myself. Thanks, Hope. I just wanted to throw out there too, sort of a topic of organizational challenges. And I apologize, I don't see the member of our committee that is in sort of that vice president type CEO. So the other challenge, we see is it's not maybe the person who doesn't want to do these exams or this work, but we're challenged with finding the organizations, the hospitals that want to pick up a sexual assault program. Just so it might be interesting for the committee to hear their perspectives and the challenges that they face in trying to do that.
Thanks for bringing up that, Brenda, because I was remiss in mentioning a component that I've had my eye on also for the March meeting, in addition to the telehealth discussion. And I kind of want some feedback from the committee on whether you feel like this is too much for one meeting, because I know in previous meetings you've given some feedback about trying to get smaller chunks for easier scheduling. We have a member of the MSU HRSA grant team that received funding to support SARN training in Montana, who is also working on her PhD and is been doing a literature review on SARN programs around the country. And what's known, for instance, from the pilot program that Massachusetts put together and what Texas has been doing in Pennsylvania and others. And I'd like to schedule a time where she could come in. Her name is Sarah Wengren. She's a former SARN nurse at Logan Health in Kalispell and is now teaching with MSU, not doing exams anymore at this time, but she's been doing a literature review of programs around the country and lessons learned or takeaways that might be helpful for us to think about as we consider the future of care in Montana and whether there are specific guidelines or other requirements that the committee would recommend. Would you be interested in taking a look at something like that, Brenda? Would that be helpful in addition to talking with folks in Montana more about their programs and what's working or not working for them?
Yeah, sure. I'm sure it covers the challenges that they've had in other states, trying to implement, like Massachusetts program, trying to implement that statewide and getting the buy-in of all the agencies or the larger hospitals. So I'm sure that would be beneficial.
Anybody else have particular thoughts on that?
Is that the same thing as the Libby McKinney?
No, different.
Different? Okay. Because I thought her presentation was informative too.
Yeah. So we had mentioned at the end of our last meeting that there was a presentation on December 6th with Dr. Libby McKinney, a nurse practitioner who's just completed her doctoral work. And she shared on her research, and there are about 6 or 7 of you who attended that. Does anybody have comments you'd like to share with the committee, or just give thoughts or reflection on what you heard in that? Do you want to?
Sure. I attended the presentation by Dr. McKinney, and she, just looking at my notes back from the meeting, but she talked a lot about, doing some research on the inconsistent education and training that forensic nurses receive. And she was, or is, I think, still a nurse in the Billings Clinic forensic program. And so she talked about the lack of training and education that they had in their program specifically, and then how that also was the same kind of picture seen throughout the state. She talked about how the nurses really had a lack of confidence, unaware of written protocols for not only, well, Montana doesn't have any really written protocols for forensic nursing, but how the nation, and they were unaware of the national written protocols regarding forensic nursing. They talked about concern with retention, which we see, and she talked about the turnover rate in nurses who are no longer completing forensic exams, and it was something that we all could relate to. And then talked about the lack of support, whether that was from their hospital, from their specific department, if they were functioning out of the ER or something like that. And I think Emily attended that with me too, and I think we can talk about how that is something that we see commonly throughout Montana and also throughout forensic nursing across the nation. Whether it's more of our urban sites, if we want to say Missoula or Bozeman or Billings, and more also in our rural sites as well. So I thought that presentation was, from my standpoint, maybe a little bit of preaching to the choir, because I totally know what she's talking about, but I think it was really informative for the other people who maybe weren't forensic nurses at the presentation.
I would agree. I think one of the statistics she threw out is like 1 in 8 nurses is still doing forensic work 2 years after coming off of orientation. So 7 out of 8 nurses leave the field at like in the 2 years after coming off orientation. I think it just speaks to like how difficult it is to maintain these programs, partially because of the erratic schedules, the difficulty nature of what we're doing. And it just makes it more interesting for those of us who stick around for a long period of time to like watch that ebb and flow. And then like as a program coordinator being like, okay, I'm going to retain like 1 nurse out of every 8 that I train. And what does that look like for us financially? And how do we move that forward and keep them in the work? Like for all the right reasons, not just because like there is a need and they feel guilted into the work.
And I think that it was also really obvious that we think about this. We don't think about this. We think about this from all the lack of things that we have in our forensic nursing activities across the state, but we also don't really have a firm grip on what the hospitals would need to be able to make that a priority. Because, you know, that we have had times in different areas of the state where we've had hospitals that had it as their priority. We had very good retention. We had long-term activity. Part of it is that we don't have many hospitals where it is part of their priority, part of their care, whatever they call it, the caregiving program, thinking they don't use it for their marketing. You know, that hospitals are just different in terms of what, you know, we need to have a what do you guys need to make this to your benefit in your mind in a way that will make it so that you will invest in it just for the public perception of you doing good. Because that is a big, huge thing with hospitals that we haven't helped them a whole lot with.
So maybe as we structure that conversation with the committee, you know, under the umbrella of program sustainability, you know, what lessons might have been learned in other states, but also, you know, what lessons have been learned here in Montana. Would you be interested in hearing from other program leaders in Montana? You know, we have Whitney and Emily here representing their 2 programs. We have others though in the state. Would you like to do a pairing with some of those other leaders and hearing about other states, or is that too much for one meeting? Would you want to segment it a little bit more?
That's probably a meeting in itself, because once you get hospital administrators in here, that's a whole nother way of thinking that we don't think at all, none of us, right? So that's going to take a little explaining how it works in their world without making, you know, them feel defensive, like, you know, why can't you guys get this done? So that might take some time. I don't know. Maybe we want to make this whole topic one meeting. Does that fit anywhere?
Yeah, we can certainly do that. And, you know, we could look to put that in March and hold the telehealth until June. We can look at trying to add dates in April and May. It's just there are several conflicts in April and May here, but also with the same trainings that are coming up that make it more challenging. You want to start talking about programs sustainability in March and have that sort of administrative side of it and hold the telehealth until the June meeting? I don't want Mark to think we're bumping him.
Go ahead and bump me. I don't care. I like to procrastinate, so that'll be fine.
We can start working on your PowerPoint now though, Mark, if you want to, so. Okay, well, let's structure it that way then for March.
So just out of curiosity, is that the hospital administration? Is that hospital CEOs? How do you get sort of the hospital administration point of view as to why they don't just fund these programs and, you know, pay their people what they're supposed to pay and make it so that they get the benefits for being on call that they're supposed to get and integrated the way they're supposed to, you know, I got all sorts of supposed to's. I'm going, why aren't you guys doing this? And I have absolutely no idea.
Yeah. Well, I think there are a few ways we can approach that. One is that we do have an administrator on the committee in Ben Huluk who could talk about experience from their side in his facility. They're working through a conversation right now in Miles City with his facility and other partners about how they can build sort of a community sane care program. There's a different facility in Miles City that's offering care right now, but they're looking to get into partnership, and there are lots of different things to consider when setting up sort of a collaborative like that they're working through those sticky wickets right now, but hoping to have that settled for 2025. So that combined with perhaps inviting someone from a long-standing program to talk about what's worked in their community and how it got started and, you know, what's kept it going for so long. And then I could think of, there is another healthcare umbrella organization that's working and thinking about how they might support. They're an umbrella for multiple facilities in Montana, and they're talking about how they could maybe build a centralized sane care service, and maybe inviting them to come talk about those considerations as well and what they've been thinking about as they work to navigate whether that's possible. Does that feel like it's in the ballpark there, Christina and others, with what you're thinking about?
Yeah, I don't know how much hospital administration thinks together. You know, they seem to think very, very differently from each other. So I'm just not sure. You know, I just want to know what motivates them and what we can do to be helpful to motivate them to, you know, to include the same programs.
Yeah, so it really feels like a transition opportunity in the work of the committee. You've been focused this first 6 months on internal learning and learning about each other's roles. And now we'll start seeing that transition into the external world where we start to engage and invite folks to come and speak with us about their experience. And we can develop that as it goes, Christina, I think. you know, we can start putting the pieces together, and if there's more information the committee wants, or if you have further thoughts about specific people who you think might bring you know, interesting pieces to the conversation, why don't you go ahead and let me know that, and we can start building the structure.
Because it's also maybe that's, you know, outside of our scope and we don't have to worry about it. One way or another, it would be really nice to see the HRSA report that she has. So that if we could look that over before the meeting, that would be great.
And to be clear, that's exterior from, so her work doing the research is exterior to the HRSA grant program itself, but certainly I think is informing her work in that. So, okay, knowing that you're interested in still hearing about that literature review and what other states have been doing, we'll work on incorporating that into this too, Christine. Yeah, Brenda?
And I just want to add, we don't know how to overcome the barriers if we don't know what the barriers are. And, you know, when you're working with communities to develop these programs, you really don't ever have the opportunity to talk to that higher level. So I think that's maybe, not to speak for Christina, but I think that's where she and I are going is, you know, just really understanding the barriers, the organizational barriers to this will help us to overcome those barriers.
Well, I will noodle on this with Kayla. Oh, yeah. And we'll work on putting the pieces together here, and we'll plan to start in February with a review of the Crime Lab's work, the prep program, a little bit of 2024 in review, and then start in March with going down that program sustainability road and learning the pieces that we need to learn to have a good conversation about those things. Sound like a plan? Okay. Well, thank you everyone for your time. Really appreciate it. And we will see you in February. I'll get the updated meeting bugs and schedules and information out to you as we get moving here. And don't hesitate to email if you need anything in the meantime, or call.
Bye, guys.
Thank you.
Take
Thanks,
care.
So much.